in a suit property at Nimalipu, your lordship, without giving me any notice or without informing me whatsoever. Decree of eviction has been passed by the learned trial court, and an order has been passed to remove me along with other occupants also. So I have been removed, and as soon as I've come to learn, I have made an application before the learned trial court under Order 21 Rule 101, your lordship, and that application has been kept pending without giving any opportunity of passing any interim order, your lordship. I'm preferring this instant revision on the basis of that. An order was passed on 7th of August of this month, but till date I have not received the certificate.
You have applied for the certified copy.
Applied for the certificate.
Please give the photocopy of that slip. You have this. You have the server copy of the order.
Yes, that I have.
Yes.
Your Lordship, may I be permitted to mention an item appearing as serial number 117 in the monthly list. Your Lordship, this is CA application challenging. This is an application challenging the improved order.
You want, sir?
I want for the upgradation, Your Lordship.
You did not mention yesterday. Yes. Call the list.
My
Lord, I am the petitioner appearing in person. I filed this application for cancellation of Vakalat Nama, my Lord. May I request your Lordship attention to page 12 of my application, which is in Annexure AA, where it was submitted by the advocate, and I quote, your Lordship, the matter was directed to appear.
Yes, Mr. Chakraborty.
my lord, this man is I'm sorry for using the word crooked. He sent this petition to he's the advocate on record, and full of in the petition he said he gave me Okala. I should give him no objection in Okala number. I am not advocate on record.
No, the advocate on record.
Second, I never appeared in this matter ever. 18th April 2025, this gentleman filed Vakalatnama for a contempt petition filed against the wife by this man, and that contempt petition was disposed of on the ground with vegetation. And in this application, he said that he handed over brief to me, handed over brief to the junior advocate. No brief he has filed. But it's a classic clear case of an application for perjury before this court.
Mr. Chakraborty, without going to ask your junior to give a no objection.
I submitted before that day that my junior will hand it over no objection. Yes. None appeared, none approached. He made some fraudulent email. My lord,
sir, why are you not approaching your advocate on record for getting no objection?
Well, he does not know the mail. He is not admissible evidence.
Where's Mr. Ghosh?
No, my lord, kindly may I request your lordship to look at his conduct. He is not given. I have, Mr. Arijit Bera has filed the Vakalat.
Why are you not approaching the learned advocate on record for taking no objection?
Well, can you see para 4 of his
lordship, may I request your kind attention to all the annexures filed in AA. I've attached the email. So many times I've WhatsApped him, I've called him, I've emailed him, and it is not reaching him. I've attached the proof, my lord. Kindly go through, if I may request.
Yes, please.
72 by rule cancellation. Rule 72 he has
quoted before the register.
Kindly count the para 4.
Appellate side rules ta dekho.
I am. Chapter 5 rule. Chapter 5 rule 72.
Rule 72.
Rule 72, my lord. Duly stamped and cancellation of the my lord, it is a true that for recovery of the lawyer's fees, High Court cannot get, due process is there, civil court is there. So why should I? Chapter 5 rule. Who got it? Chapter 5, Rule 72.
Yes, I've got that.
But they can't be before the court because they deserve the adjudication.
But it does not say that it
That does not say, my lord, because that is the problem.
Yes, what does it say?
Seen from the observation made and decision extracted above, a party to a litigation has the absolute right to appoint an advocate of choice, terminate his services, and to appoint a new advocate. A party has the freedom to change his advocate anytime and for whatever reason. However, fairness demands that the party should inform his advocate already on record. Though this is not a condition precedent to appoint a new advocate. After this, having
So he has communicated, I am passing an order that the Vakalat stands cancelled.
Obliged, my lord.
With the
Obliged.
going into this.
Much obliged.
Well, the allegation only
Much
three.
obliged.
Vakalatnama in which proceedings? Where have you stated?
CO 3571 of 2024, my lord.
3571 of 2024, you have filed the Vakalatnama.
Yes, 18th April. 18th April.
This is an application for cancellation of the Vakalatnama. Accepted by Mr. Orijit Bera, learned advocate. Full stop. The petitioner appearing in person submits that in spite of several requests, the learned advocate has not endorsed the no objection on the Vakalatnama. Full stop. Pursuant to the order dated 11th of August 2025, a copy of this application has been duly served upon the learned advocate. Full stop. The learned Mr. Bera, learned advocate, is present in court. Full stop. He submits that the petitioner has not approached him for taking the no objection. Full stop. Without entering into such controversy, it is recorded that the Vakalatnama accepted by Mr. Orijit Bera in CO number 3571 of 2024 stands cancelled.
Well, he made some allegations.
This court has not gone into the allegations made in the said application. In view of this order, this court has not. In view of this order, this court is not this court is not inclined to. This court is not enter into the allegations made in the application since the learned advocate appearing for since the learned advocate has submitted that he is ready and willing to endorse the no objection. Can dispose of. Yes. After say rules ta khade ekhane.
Calcutta High Court rule is binding.
Item number 3.
Mr. Chakravarti, do you want your name also to be recorded? I think it's not necessary. Huh? Yes. Where is Mr. Rai?
Is it my lord on his leg?
Every day.
Difficulty, my lord. I'll just indicate, my lord, the judgment, my lord, is not, my lord. He could not obtain it, my lord.
Not accepting the written that I have declared upon. Say that it is not a deed.
All right. Then I'm.
Bhattacharya, I do not know whether he has found anything.
Because yesterday, Mr. Rai's Jr. told that Mr. Rai has got one decision.
No, my lord, Mr. Dash was there. My lord, this has been the stand throughout, my lord. The judgment, my lord, of Justice Shubhra Kamal Mukherjee, my lord, there is nowhere available, my lord.
might be not a reported decision. All right. Heard the learned advocates for the respective parties in. If you find Mr. Booker, I have tell you.
Just mention and give, not I'm on a lookout. If there is
Yes,
anything-
because if there is something contrary.
The facts of this case, Lord, it will be very difficult because as we said, that it never, not ended in culminity of the industry.
Yes, facts is that, yes, as you have made your submissions, but I am on the fact that what would be in case of mere acceptance without a decree, if you get that, because I have to, if there is any decision, should not be contrary to that.
Lord,
Maybe it can be distinguished on the facts of a case, that's a different thing. If it runs counter to a decision,
Lord.
that is not good. Yes. Thank you, Mr. Mukherjee. Yes, call the next
Number
matter.
4.
No, no. CAV.
Number 4, your
Any-
Lordship, I am appearing on behalf of the opposite party.
Lordship, Mr. Aniruddha Chatterjee, learned senior counsel, is appearing in this matter for the petitioner. Your Lordship, the opposite party has mentioned this matter yesterday, I think, without giving any notice to the petitioner, Your Lordship.
Yes, Mr. Why would mention without giving them notice? What is this matter?
Your Lordship,
7.2, that matter regarding
the Supreme Court has,
continuation of delay in terms of 7.1c.
yes, Your Lordship, the Supreme Court has disposed of the matter, but Mr. Aniruddha Chatterjee, learned senior counsel is outstation, Your Lordship. He will return after 26th of this month, Your Lordship.
Your Lordship,
Kindly fix the matter after 26th of this month.
what improvement
Where is Mr. Chatterjee?
He is outstation. He is not in the.
Vacation started.
I don't know, Your Lordship. Just now his clerk has informed.
Yes,
that
Mr. Pan, vacation started.
They have not
Must
given
be
any
knowing.
notice. They have not given any notice.
Please inquire and let me know before 4:30.
Kindly fix after 26, Your Lordship.
what improvement
They have not given any notice. It is just after checking the list we have came to the notice about this matter that they have mentioned yesterday, Your Lordship. This is the contested application, Your Lordship.
Mr. Sara, I did not say that it will appear under the heading to be mentioned.
did not say anything. Your Lordship, yesterday you mentioned
I have asked you to hand over the slip. Why it is appearing under the heading to be mentioned?
that automatically appeared under the heading to be mentioned.
Your Lordship,
To be mentioned the Dilan
Your
Kannada.
Lordship has directed to appear the.
Keep it under the heading to be mentioned.
No, Your Lordship, I had only
Yes, yes, this is your mentioning slip.
I had only submitted this slip yesterday. Your,
Yes, see,
yes, Your Lordship.
so
Your Lordship had
you
taken,
have given the slip for to be mentioned. Now you are saying you have not said.
but Your Lordship taken the slip and not mentioned anything.
You have mentioned it yesterday. I have asked you to hand over the slip.
Yes,
I have not said that this will appear, but you have given there to be mentioned. I have not said under the heading to be mentioned.
it has to be mentioned in this slip, Your Lordship.
Your Lordship, you have directed by your order to appear in the heading contested application.
Let the matter go out.
Item number 5.
In this matter, my lord, that your lordship was pleased to,
Modification
yes, my lord,
within 4 months.
yes, my lord.
Now,
My lord,
that
that,
done.
my lord, that was not written in this, my lord. But your lordship's order was that I, on the previous occasion, submitted that within December, we must pay the amount. Your
Yes.
lordship will see,
And
and
so, have you stated that in the affidavit?
No.
So, it has to be stated.
my lord, if you,
Attempt not to file an affidavit stating the entire process shall be made by
my
the.
lord, as because my lord, if your lordship will go through my affidavit, then my lord.
When we have a look at it.
Actually now, then Dada.
That is why, because on the earlier occasion also that was not stated, that is why.
সবাই ভয় পাচ্ছে মুশকিলটা অন্য জায়গায় কোর্টকে সবাই ভয় পায় তো অফিসাররা মুশকিল অন্য জায়গায়
No,
that
no, no,
within
Mr.
December.
It has not been. That is why you submitted. I have told you that don't take it on your own shoulders. Let an affidavit be filed.
But my lord, your lordship, yeah,
In order to save you, Mr. Dey.
I
That
know
is
my
why
lord,
I directed the filing of the, because I have recorded your submission. Even then, I have asked you that let an affidavit be filed.
my lord, your lordship can, as because my lord, if your lordship paragraph 2 and 3, my lord, if your lordship will go through that the district magistrate in his report dated Ato requested the additional chief secretary to the government of West Bengal land and land reforms department for approval of sanction. He requested estimate of 1,61,000 and others. That after gone through the order of the honorable court, my lord, in the above matter, the collector Murshidabad personally look into the matter, and after collecting the market value from the district registrar, Murshidabad sent proposal for approval. My lord, we have started the proceeding, and we have already.
Yes, no dispute. I'm not disputing. I think Mr. Pan will also not dispute that you have started. But that's the difficult thing. Where it will end. End point is very. That has to be.
My lord, that is your lordship can pass the order. Your lordship.
Mr. Dey, that is, please file an affidavit stating that it will be done with
My
the
lord,
court.
Why they are not coming with an affidavit?
Because you want modification
That is
on
the
your
affidavit.
statement, otherwise there is no necessity to modification. So you said that I will do within that time. I'm giving you liberty to file a fresh affidavit in terms of this order.
And also, one more thing, one more.
My lord, one thing I must say, my lord, before your lordship. My lord, petitioner should file contempt. When file contempt, he should file the requiring body is a contemptor. As because my lord, money will be paid by the requiring body, not by us. My lord, without the
Mr. Dey, that is a different.
that is the law. My lord, that is the law. As because my lord, why law is that, my lord?
Mr.
Money
Dey.
will be paid by the requiring body. And my lord, I am guilty of all the proceedings and other things.
Mr. Dey, it's not contempt. I have not yet taken up the contempt application. Why are you going to the contempt? So
No, I am not.
Now you have filed an application for modification. I'm considering.
Well,
only
they
that.
are fair with the as
Hey, you have submitted, it will be done within 4 months. I asked you, why are you
They are
taking it
ready
to your own shoulders? Let an affidavit be filed with regard to that.
well, for that reason, my lord, they have filed that they have started the proceedings.
Started,
And have done-
Mr. Dey, they have not said when it will be concluded. When it will be concluded, that has not been stated.
For that reason, my lord, that part, the district level, particularly would swing into action immediately to comply the order of the honorable court.
Mr.
Well, if
Dey,
your lordship pass the order, what is the harm of it?
what?
That is the money will be paid
Mr. Dey,
within
Dey, it's not.
31st
Dey,
December.
I will not pass any order modifying my earlier order, suo motu, unless there is a statement on affidavit.
Go by the order.
I will not modify on my own.
Yes, ma'am. Then I
So that is why I'm giving you liberty to file a supplementary affidavit. The supplementary affidavit Item number 6, Mr. Halda, that's Borga, come at 2 p.m. Yes, 2 p.m. at 2 p.m. now. Yes, next.
Item number 7. Lord, I am appealing for the petitioner.
Yes.
My lord, in a connected matter, my lord already passed an order dismissing my application.
Handwriting.
Yes, my lord. This order has come now. This is one of the matters where my lord passed the order.
All right. So, in
What-
terms of this order,
My lord, the petitioner's name and the case number will change. Nothing else.
petitioner's name will change.
Yes, my lord. This is a
Opposite party is the same.
same opposite parties, only the petitioner is different.
All right.
And the case number.
All right.
Item number 8.
Milord, I have given it a thought. Milord, this is the matter where, Milord, Order 21, Rule 54, Milord, the wife was an
58.
objector. 54, 58, both, Milord, there are two orders.
Yes.
Milord, in anticipation, I filed, Milord, Order 21, Rule 58 by, Milord, Order number 101 that was rejected. Because of, Milord, Rule 4, Sub-Rule 4, it's an appeal level. Now, Milord, coming to the next order, order number 103, where, Milord, the learned executing court has held that when the property should be demarcated in the execution proceeding for proclamation and all, Milord. There, Milord, in order 21, Rule 54 matter, Milord, I was otherwise not a party. I was a party in, Milord, my miscellaneous application under order 21, Rule 58.
If that goes, how can you make an
Milord, I have an answer to that. It's, Milord, troubling me also. Milord, may I just open my mind up before your lordship? Milord, let us assume that, Milord, there was no objection at all. Even then also, Milord, the learned executing court did not have the jurisdiction, Milord, to order that, Milord, the property should be partitioned and demarcated. Milord, I am on that. And, Milord, in order to file a divisional application under 227, even, Milord, under 115, Milord, in the past days, My lord, I need not necessarily be a party, my lord, before the learned trial court. That is what, my lord, is troubling.
No order has been passed against you.
My lord, against
Because order 21 rule 54,
yes,
it's
not
prohibiting the judgment data from transferring, charging such and such.
kindly, my lord,
That is only against the judgment
kindly
data.
have a look at order 21 rule 54, my lord.
Yes, yes.
My lord,
Yes,
I'm sorry, my lord, I'm troubling your lordship.
yes.
Where the property is immovable, the attachment shall be made by an order prohibiting the judgment debtor from transferring or charging property in any way, and all persons from taking any benefit from such transfer or charge. So, my lord, this prohibition would be, my lord, restricted to the judgment debtor's property.
Yes,
Kindly, my lord, have a look at section 60 of the code, which says, my lord, which properties are, my lord, amenable to attachment.
Yes.
Can you, my lord, see the language of subsection 1 of section 60?
Yes.
The following property is liable to attachment and sale in execution of a decree. My lord, I skip over. All other sellable property, movable or immovable, then it says, qualifies, my lord, all belonging to the judgment debtor, or over which the profits of which he has a disposing power. My lord, this being an undivided, my lord, property, he has a disposing power over undivided half share.
Yes.
My lord,
And he has been restrained only with regard to his share.
kindly see, my lord, the third last paragraph. I'm sure my lord has marked that last yesterday. Third last paragraph, my lord, in page 1, first page of the, my lord, order number 103. My lord, my grievance lies there only. This is something wholly without jurisdiction, while, my lord, the learned executing court is exercising power under order 21 rule 54, read with section 60. This is without jurisdiction.
Mr. Banerjee.
Yes. Yes,
only-
the demarcation shall be carried out.
Mr. Banerjee, there are two things.
Yes, my lord.
Here it says demarcation shall be carried out to
Ah.
distinguish. Mr. Banerjee, the difficulty is that
Yes.
you are identifying yourself being the wife with your husband. That's the difficulty.
Let me not
So
identify
here
also.
yes, here the court is very clear in its order. Says judgment debtor's property. What will be done? You are not a party. You are not a party.
If demarcation is directed,
Yes.
what is directed, then it affects my right. Straightway affects my right. It says measurement and demarcation shall be carried out. Distinguish the portion of the land belonging to the judgment debtor. That clearly affects my right. This is an invasion. Because I being an undivided owner, it's between me and the other co-owner, to have it demarcated by metes and bounds. Which
I will
portion,
clarify that this observation will not bind you. Since you are not a party.
and kindly also grant us liberty to approach appropriate forum
That is with
from
regard to the other.
previous order.
With
Yes.
regard to the other.
Yes.
Uh, This application under Article 227 of the Constitution of India is at the instance of a third party, challenging the orders being number 101 and 103, both passed by the learned civil judge within bracket senior division, first court at Asansol in miscellaneous case number 24 of 2024, arising out of title execution case number 2 of 2014. By the order being number 101 dated 13th of May
May I
2020.
interrupt once. 101 is in miss case.
Yes.
103 is in title execution case. Mine was a miss case, Milord miss case 24, but Milord order 21 rule 54 order was passed in title execution case at the instance of Milord the decree holder.
See your cost title, what you have said in the preamble.
Well, that's incorrect. That's wrong. That's wrong. Milord.
একদম উপরে লিখে দিন
Yes.
on the prayer of Mr. Banerjee, learned advocate for the petitioner, leave is granted to the learned. Yes, Mr. Banerjee, please correct it. Leave is granted to the learned advocate on record of the petitioner to correct the cost title of the civil revision application, comma, here and now. তারপর হচ্ছে this application under Article 227 of the Constitution of India. এটা কেটে দিন, কেটে দিয়ে একটু this application under Article 227 of the Constitution of India is at the instance of a third party and is directed against an order being number 101 dated 13th of May 2025 passed in miss case number 24 of 2024 and the order being number 103 dated 17th of May 2025 in title execution case number 2 of 2024 2 of 2014, both passed by the learned Civil Judge Senior Division First Court at Asansol. First up, by the order being number 101 dated 13th of May 2025, the miscellaneous case number 24 of 2024 arising out of an application under order 21 rule 58 of the Code of Civil Procedure stood rejected. Full stop. Mr. Banerjee, learned advocate appearing for the petitioner, submits that the said order is an appellable order, and in view thereof, he prays for leave to withdraw the civil revision application
Quay the said order.
with regard to the in respect of the said order, with liberty to approach the appropriate forum. Mr. Banerjee further submits that by the order being number 103 dated 17th of May 2025, the right of the petitioner Mr. Banerjee, learned advocate appearing for the petitioner, submits that the petitioner is aggrieved by the order being number 103 dated 17th of May 2025, as by the said order the joint property belonging to the petitioner and the judgment debtor was directed to be partitioned. Full stop. He therefore submits that for such reason the petitioner is inclined to, the petitioner intends to proceed with the civil revision application as against the said order. Full stop. Paragraph. He further submits that order order 21 rule 54 only permits a prohibitory order to be passed against a judgment debtor and not against any third party. Full stop. He submits that the order impugned affects the right of the petitioner herein, who is one of the co-owner of a property which was the subject matter of attachment. After going through the order being number 103 dated Order 21 rule 54 of the Code of Civil Procedure states that where the property is immovable, the attachment shall be made by an order prohibiting the judgment debtor from transferring or charging the property in any way, and all persons from taking
Great.
Number 9.
But item number 9, my lord, I am for the petition. But this is an extension of interim order, my lord.
You are appearing for the opposite party. Yes, the interim order. The interim order is still subsisting.
My lord, August 25.
The subsisting after hearing the learned advocates for the respective parties.
Item number 10 with 11.
Yes, Mr. Datta.
See also extension of the interim order.
Yes, you are appealing for the opposite party. The one and there are other opposite parties also.
One and one.
Only 1 and 2. After hearing the learned advocate for the separate orders were passed or single order was passed? দেখে নিন একবার কিন্তু তাহলে সেপারেট অর্ডারস থাকলে সেপারেট অর্ডারস
Twelve.
For the petition. This is for extension of interim order. The interim order is till end of August.
the subsisting interim order is after yes, call the next matter.
Number 13.
Lordship, this is my affidavit of service. Lordship, she is appearing for some of the opposite parties.
Yes,
Regarding the others, Lordship, it has come back with endorsement that no such person in that address.
Then left not good service.
Then again, Lordship, kindly.
They are not contesting.
No, they have not also appeared in the suit also, Lordship.
They are the effective parties. You are the plaintiff.
Yes,
They are the contesting defendant.
Lordship.
What is the impugned order?
Lordship, order 26, rule 9 was kept in abeyance, Lordship. So, Lordship, the interim order is subsisting till the end of August, Lordship. The learned trial judge held that after all the evidence is taken place, then my application will be considered.
After hearing the learned advocates for the respective parties, affidavit service filed in court today is taken on record. Mr. Chakraborty, learned advocate submits that the some of the opposite parties, that the registered envelopes addressed to some of the opposite parties returned with the endorsement addressee cannot be located.
No, no. Addressee cannot be located, returned to sender.
Addressee double inverted,
And no such person in this address not known.
double inverted comma, no such person at the address.
In this address not known regarding opposite parties number 1 to 3. And regarding 7, addressee cannot be located, sent to address.
আচ্ছা তাহলে ওই অত লেখার দরকার নেই। The registered invoice addressed to some of the opposite parties returned unserved, ঠিক আছে, অত ওই ডাবল ইনভার্ট লিখতে হবে। The opposite party numbers
4, 5 and 6.
4, 5 and 6 are represented by the learned advocate. So after hearing the learned advocates for the respective parties, the subsisting interim order,
Yes, yes.
subsisting interim order is extended till the end of the month of January 2026 or until further orders, whichever is earlier. Matter is appearing in the list. List the matter under the heading contested application after 12 weeks.
Grateful. Deeply obliged, my lord.
The petitioner shall serve a note, shall communicate this order to the non-appearing opposite parties and file an affidavit of service on the next day. Yes, next.
Item number 14.
Please, Your Lordship, my application for extension of the interim order. Lordship, the interim order is substituting in the end of August.
You have filed an application.
I filed an application.
Why?
My letter is appearing. Lordship, my
You are
affidavit of
appearing.
service.
Yes,
Affidavit of service.
I'm extending the interim order.
Leave may be granted to me to file an affidavit in opposition.
Why? Civil revision application, why affidavit in opposition?
Lordship, also, can I
What
take,
is-
yes.
What is the impugned order?
Lordship, the impugned order is, this was an order passed under section 253 of the Indian Succession Act, wherein I was led by Mr. Chatterjee. I was asked to deposit a sum of indemnity bond to the sum of rupees 1 crore 60 lakhs because I had intermeddled into the estate of the.
After hearing the learned advocate.
Party is insisting.
If you have some documents have not been annexed, you bring that, I will look into that. Affidavit in opposition in a civil revision application for other purpose. Want it for other purpose. All right. Before vacation.
Item number 15.
Lordship, for the petitioner, Lordship. This is my affidavit of service, Lordship. This is for extension of interim order, Lordship. Let it be extended.
অ্যাপিয়ার করছে না কি আছে কারণ আমাদের কেভিএটার কপি নিয়ে যাবে
Caveator was served. Ruiz versus Rai did not appear when the matter was moved.
No, thereafter, Lordship, he
There's a
changed
case,
phrase.
It is recorded as submission that the caveator was served. Yes, what is this matter? What
Lordship,
is the impugned order?
Lordship, amendment of written statement was allowed, Lordship.
Allowed. The subsisting in Yes, next.
Item number 16.
Yes.
Appear for the petitioner, my lord. Before my lord takes comes from Baripur, my lord, and
I should release. Tell me that. Why are you hesitating?
Number 17.
Yes.
appear for the petitioner, my lord. Eviction suit praying for expeditious disposal, my lord.
What is the stage?
Well, 7172.
Order 22 rule 2.
Yes, 7C has been done. Original different.
27C order 22 rule
I'm
2.
praying for disposal of this application. They are not filing the date report.
Order 22 rule 2.
Yes.
We want this application to be expedited. This application under article.
Lord, I'll have to seek instructions for this matter, my lord.
Why?
If my lord,
What instruction?
Lord, this matter is challenging, my lord, maintenance order, my lord, quantum of maintenance, my lord.
Yes. Quantum
Lord,
of maintenance, you want enhancement or you want
reduction, my lord.
reduction?
I'm for the husband, my lord.
What is the amount of alimony?
My lord, 16,000 in total.
16,000?
Lord,
Wife and child. Do you mean to say that
Lord,
is
my
sufficient?
income is, my lord, 9,000.
Your income?
Yes, my lord.
Now or at the time of marriage? When the proposal came for
Lord,
marriage?
for that, my lord, I'll
At
have
that
to.
point of time, your earning was much higher.
No, my lord.
After marriage, income decreased.
Not that, my lord. My lord, I have filed, my lord, the affidavit of assets as well as, my lord, my.
What is the finding with regard to your income?
My lord, kindly seize the impugn order.
Oh, father's medicine shop you are working.
Yes, my lord.
So after all, it's your business.
Lord, not yet, my lord. It's a joint family business.
Not yet. It's after all your business.
Lord, it is difficult for me, my lord, alone to, my lord, pay that amount of money, my lord. Because anyway, my lord, the property also, my lord, where I live, my lord, it belongs to a joint family. My lord, I have annexed my income slip as well.
That is your
Income
father
tax.
is issuing that.
Income
Father
tax.
is issuing that.
My lord, the income tax return, my lord.
That is your declaration. Your declaration, everything manipulated within the medicine shop. Father giving to the son, that is on that basis your income tax return.
At this
Have
moment,
you
my lord,
annexed
the
your
shop
father?
belongs to the
Have you
father.
annexed your father's income tax return or
No,
the
my lord,
profit and loss of the medicine shop?
that I have not, my lord, annexed. Lord, may I come back with all those documents, my lord, on Tuesday, my lord? If my lord keeps the matter on Tuesday, my lord.
Where is your affidavit of assets and liabilities?
My lord, that is page 51. Page 51, my lord.
You are an income tax payee.
My lord.
Income tax payee. Why? 9,000.
9,000.
Within taxable limits.
Within tax. Within tax. Within tax.
You are a tax payee.
My lord, for that, my lord, I'll have to take instructions, my lord.
What you will have to take instructions from income tax return? It will be evident. Why have you filed income tax return when your monthly income is 9,000? To create an evidence in this suit for the purpose of this alimony application.
My lord, I'll have to take instructions on that. My lord, if my lord keeps the matter on, my lord, Tuesday, my lord.
Are you paying this amount or you are not paid?
No, my lord, right now, my lord, I have not paid that amount.
Your suit has to be stayed then. The petition, the learned advocate appearing for
Number 19.
none appears for the petitioner at the time of call, no action 20. Yes.
This is an application for expeditious disposal of the miscellaneous appeal pending before the learned court.
Miscellaneous appeal. Miscellaneous appeal is arising out of
Injunction.
injunction. What is the stage of the miscellaneous appeal?
My lord, the TCR has not come to.
This application under Article 227 of the Constitution of India is at the instance of the
One. My lord, I am referring for the petitioners.
yes. What is this application for?
My lord, against the order dated 24th April 25, my lord.
Yes. Yes.
My lord. My lord, I have annexed order dated 16th April 2024, my lord.
15th April 2024. 16th April, yes.
16th April.
Yes. Status quo order was passed.
Yes, my lord.
Who are you?
My lord, I am for the petitioner.
Petitioner, I understand. Plaintiff of the defendant.
Plaintiff. My lord.
Yes.
My lord,
Yes. What is your submission?
my lord, my submission is to maintain status quo, my lord.
That has been granted.
No, my lord, the petitioners was restrained, my lord. Petitions were restrained. My lord, kindly see the order in force. Order dated 24th April 25.
Where is the 151 application?
My lord. I have annexed the on
Page.
page 18, my lord.
By the order impugned, the yes, yes, Mr. Haldar.
The plaintiffs are the petitioner before your lordship. This revision is directed against an order by which my application for amendment of plaint has been rejected.
Amendment of plaint rejected.
Amendment of plaint rejected. The plaintiffs are the flat owners of the property in question. If your lordship kindly turns to the prayer portion of the plaint at page 15. 1.5. For a decree of declaration.
Yes.
For a decree of declaration that the defendants have got no right, title, interest on A scheduled property and B scheduled property, which is absolutely meant for common user of all the flat owners of the apartment, namely high-tech view apartment. For a decree of permanent order of injunction for restraining the defendant number 1 from making any illegal construction on the common passage or on the storeroom or on the car parking.
Yes, where is the application for amendment?
Page 17.
You are appearing for the opposite party.
Yes,
yes.
Caveat law.
Number 1, the caveator, my lord.
Yes. 17. Yes.
The amendment has two parts. Page 17. Amendment has two parts. During pendency of the suit, some flat owners transferred the suit property to some outsiders by way of amendment.
Flat owners transferred
the suit property to some new purchasers.
Yes.
I paid for amendment by way of amendment for their implement. And it has second parties. During pendency of the suit and during subsistence of the order of injunction, the defendant number 2, defendant number 2 is a developer, and defendant number 1 is also a flat owner. Defendant number 2 transferred A and B scheduled property in favor of the defendant number 1. Which is mean for.
So now the defendant number 1 is the owner. Yes.
The defendant number 1 is contesting the suit and he is objecting.
Yes.
By virtue of this amendment, it has two parts. First one is the implement of those parties. And the
implement by way of amendment.
By way of amendment.
Can it be done?
I am asking, coming and the second one is during pendency of the suit, he has transferred the suit property in favor of defendant number 1. So I paid for, I challenge the said deed that deed is in violation of order of injunction. That said transfer has been made. So I have challenged the deed. If you will also kindly have a look at one by one, kindly come to under schedule.
Give me a minute. Yes, Mr. Haldar, one part is right. For addition, amendment
But
is not the,
nomenclature is not the deciding factor. Court would look, nomenclature is not the deciding
not the
factor.
nomenclature. Yes, there are decisions. You have to apply because, apply whether it's under Order 22, Rule 10, because devolution of interest during the pendency of the suit, it is Order 22, Rule 10, appellable order. I cannot touch it. Take it back, file an appeal. Nomenclature, I accept. Appellable order, Order 22, Rule 10, rejected. Because devolution of interest, pending suit, Order 22, Rule 10. That's the provision. Nomenclature is either way, Mr. Haldar, you go.
But if you lost visualize in this,
Correct,
it is
provision is applied, appeal. Withdraw it, approach the appeal.
Order on Rule 10.
No, cannot be. Devolution of interest due to the pendency of the suit, provision is Order 22, Rule 10. Even if you caption it as Order 1, Rule 10, it has to be considered as Order 22, Rule 10, appeal lies. Caption is not material, you have said. Has to look into the substance. That's your submission. So if the substance is to be looked into, it's devolution of interest.
That's called and trial judge was pleased to reject. But so far as the second part is concerned, kindly have come to page 19. Page 19, paragraph 5. Page 19, 19. Paragraph 5. That in the plaint after paragraph 7, a new paragraph as 7A shall be inserted as follows. That
paragraph 4 also. Paragraph 4 also you have stated 3A, 3B, 3C shall be inserted.
Yes. Those are so far as the devolution of interest is concerned. So up to 3C.
Oh, no, 4 also. Royalson is a necessary party and his name. Oh, 4 also is addition. 5 also.
Yes. 4 covers 3A, 3B, 3C.
So that is addition.
So far as the addition is concerned.
Addition during the pendency of the root. But this was not considered.
This was, my lord, held there is a specific provision for addition. So
addition is one part.
Yes.
With regard to paragraph 5.
5 and 6, no discussion at all. 5 and 6, I paid for declare. My lord,
Haldar, you are responsible for that. Filing a composite application. So the court thought, because I also was under the impression paragraph 4 is amendment, but then I found no, it's for addition. So I give you liberty to file a fresh application that will be considered. It's difficult, Mr. Haldar, here.
And so far that is one part, and so far as the second part is concerned, my lord, I have challenged the deed because in the teeth of order of injunction, my lord, he cannot transfer it.
I appreciate that, but you have combined everything in one application.
Give me liberty, my lord.
I think, yes, what do you say?
My lord, not only that, my lord, this application of Order 6, Rule 17 was filed in 2023. Order 6, Rule 17 was filed in 2023, my lord.
Yes.
And after they have...
An earlier application was filed.
No.
This application in 2023.
2023. Then
yes.
In 25, they have filed an application for amendment of that. Kindly come to which...
I could not follow your submission.
But that Order 6, Order 7, Order 6, Rule 17 was
filed. I took out an application for recalling of the said order. That was also rejected. I have challenged both the orders. I have challenged both the orders before your lordship.
Both the orders in one
application
cannot be done. Yes. How can you challenge 2 orders in one civil division application?
I will pay the balance court fee, my lord. GP giving my lord to pay the balance court fee.
Necessary, Mr. Haldar. You are saying you will pay balance court fees. What's the law? If the recalling has been rejected, what do you have to challenge? It's only the parent order which is to be challenged.
I have also challenged this.
Yes, so why do you require to pay the double court fees? Not applying your mind. He's saying, and I've asked you, you are saying double court fees.
The parent order is for 2023, my lord. He has
so what's the law, sir? If an application for review, it's though recalling, it's review. If review is rejected, what is to be challenged? It's the parent order which is to be challenged. And for the purpose of explaining the delay, this can be said.
There is no delay.
2 orders are not required to be challenged. By abundant caution, he has challenged both. So we can consider the parent order. Yes, what do you have to say on merits?
On merits, my lord, kindly allow me to file an affidavit, my lord.
Of opposition. What for? What for? What do you say in the affidavit of opposition? Please make that submission. I will consider that. No necessity to. I will accept that. Yes. What will state in the affidavit of opposition?
Today morning itself, I have received the brief.
Don't make mechanical prayers for affidavit in opposition. What do you have to say in affidavit in opposition? Please tell me that.
Today morning itself, I have received the brief. My lord, kindly allow me some time. Let it become.
Ashun, this application under Article 2
And for the petitioner, defendant number one, praying for expeditious disposal of the suit. My lord, the problem is that the 10-year have been passed. The learned court will only fixing the date for SRAD and appearance.
SRAD?
SRAD and SRAD and SRAD. My lord, the problem, my lord, if my lord will kindly come, my lord, if my lord will
Unless
kindly,
the,
the problem is that the learned court below regularly giving a direction to the plaintiff to take steps,
Has
but
to
the
be
plaintiff,
done.
but the plaintiff is not taking any steps. My lord, there is an injunction ad interim order. That is why my lord, we are suffering. And only pay, my lord, kindly.
Ad interim order, why you are suffering?
My
If
lord,
you are
no,
there,
my
if it is against you, you can take steps.
no, my lord, but my lord, I'm not. Let the suit be disposed of. My lord,
Cannot
that
be-
is my only. My
cannot
lord,
be done.
kindly, my lord, give an expedite direction.
Cannot be.
My lord, because my lord, if my lord, kindly come to order number 27, my lord. Once.
Yes.
The order number 27, 24, 11, 22, the order dated. My lord, the plaintiff find
SRAD, sir, unless the service is
until and my lord, from the 10 years have been passed, my lord.
take steps there.
Then how can I? My lord, there is a direction upon the plaintiff. If the court will direct me, I can.
This application under Article 227. Call the next matter.
I'm grateful.
Yes, ma'am. Appearing for the plaintiff petitioner, my lord.
Yes.
My lord, being agreed, order passed by Civil Judge Second Court, Howrah, order dated 8th July 2025, with regard to the amendment petition filed by the defendant, my lord.
What is the date of the order? 8th of July.
8th July 2025.
Yes.
Now, my lord, I have to advance my submission. There's an order of expedite the matter of injunction application and the suit too. My lord, passed by Honorable Justice Sampa Pal Dutt. Annexation number, which I have annexed. Page number 89. Now, my lord, I have duly communicated the order passed by Honorable Justice Sampadat Pal for expedite the matter of injunction applications of both the parties filed there and the suit too. Now, after getting that direction, after noting that direction, the defendant has filed two applications for amendment. One is for amendment for counterclaim, and another application has been filed under section 153, read with 151 of CPC regarding the amendment.
Where is the application for amendment?
No.
Of the written statement.
Annexure H. Annexure H.
My lord, come to page number 95. And that is the application for amendment of counterclaim. My lord, here, by way of amendment application, they want to insert the property that is scheduled Y. Earlier in the counterclaim, they have inserted the schedule of property as X. And that is the reason I have given objection over the matter. Kindly, my lord, come to paragraph number 2. What the reason they have cited or stated with regard to the amendment application. My lord, in paragraph 2, they have stated at the time of filing.
Where is the original written statement?
Original written statement? Page 65. My lord, page 6. Page 54. Page 54, my lord. Page 54.
So they are trying to now change the schedule.
Yes, my
of the counterclaim.
Yes, my lord. That's the only grievance I have filed written objection over the matter, stating that the nature and character of the suit property change, it affects the cause of action based on the earlier schedule of property. Now they have inserted the new property as Y schedule property. My lord.
Number 25.
I am for the plaintiff petitioner before your lordship.
I am for the caveator, respondent number 1.
This is a suit for declaration and injunction. In that, my lord, court granted adding injunction not to construct without any sanction plan to the opposite party number 1. Against that, they have made an appeal. They had also get an order of status, my lord, stay of the operation. Kindly come to my lord, page 22 of the injunction application. What is my prayer? Page 22, my lord. In accordance with your honor, may be pleased to pass a temporary injunction against the dependent number so that she may not disturb the peaceful possession. A schedule property is my, B schedule property, the opposite party number 1, may not construct any construction over the B schedule property without any sanction plan and without keeping any 4 feet wide open space, not done boundary side from my side. My lord, thereafter, my lord, kindly come to page 25. Page 25 is the his land that is also recorded as Pukur Par, my lord, not even at Bastu. My lord, bottom, my lord.
Yes.
Pukur Par. My lord, finally come to the order of the trial court. My lord, last paragraph, first page. Hence, the plaintiff prayer for identity is considered and allowed in the form of defendant is restrained from in disturbing the peaceful possession of the A schedule property situated district Pashchim such and such, and may not construct the B schedule property situated such and such in Pukur Par without any sanction plan, without keeping any open space. That means, my lord, he may, if there is a sanction plan, he may be constructed as per sanction plan. My lord, I specifically prayed that he has not stayed.
My lord,
how can an order of injunction be stayed?
My lord, the order of injunction has been stayed by the learned.
How? Without giving any reasons?
My lord, that reasons has been given here, my lord.
Where?
Order impugn, my lord.
My lord, order impugn
Show me the reasons.
My lord, considering learned advocate for the appellant moves a stay application, the heard the learned appellant peruse the petition.
Yes, show me the reasons.
Considering the fact that
I'm also passing a one-line order. Considering this, I'm vacating.
vacating, well, no, not vacating, my lord. Date has
No,
been-
I'm vacating. Considering all everything, I'm vacating.
That's it, my lord, that's a note. But the date.
If this is the reason, I can also give one line.
My lord, 8th of my lord, one thing, may I pray, my lord? May I pray, my lord, one thing?
I'm directing the miscellaneous appeal to be
Hard, my lord, decided within 1 month, my lord, 8th is the date. Next.
My lord, constructing, regularly constructing.
stay order has to be vacated.
Yes.
This application under Article 227.
This affected, my lord, the
disposal. Not the affidavit of service.
letter, my lord, letter.
Later, keep it with you.
When we are appearing, well, nothing.
Yes, next.
Order number 26.
26, I appear for the petitioner. This is a suit for recovery of possession on the ground of building, rebuilding, and defaulter.
Yes.
Lord, so far as building, rebuilding is concerned, my lord, it is settled law that after degree for recovery of possession, my lord, I have to, my lord, after construction, I will have to hand over the possession in respect of the tenanted premises to the tenant. My lord, I file an application under Order 39, Rule 7. My lord, only on the ground that, my lord, I am not aware what is the actual measurement of the tenanted premises. Because, my lord, at the time of sanctioning of the building plan, my lord, I have to submit, my lord, what is the extent the tenant is holding in respect of the property. That kindly comes up my application Order 39, Rule 7 once. Page 23.
Where is your application?
23, lords.
Page 23.
Learned judge has proceeded on a different premises. Section 11. And the points is at page number 25. Just to measure the area, my lord.
The learned advocate appearing Yes, next.
Number 27.
Your Lordship, I am for the petitioner, Your Lordship. This matter pertains to expeditious disposal of the of a title suit which was pending before learned
What is the stage of the suit?
ex parte hearing, Your Lordship. But the dispute is the parties are not arriving, the opposite parties, and the in the court.
Application under
Submission, Lord, the matter is not at the stage of issue. Lord, the evidence of the PW1 is going on.
ওখানে একটা লিখে দিন, the suit is at the stage of evidence. Yes, next.
Number 28.
I'm appearing for the petitioner defendant in a suit for eviction. My 7-2 application has been rejected, Your Lordship, by the impugned order. There are two impugned orders. One was for payment under 7-1 and
yes.
7-2, Your Lordship, kindly sees the order dated 25th of July 2025.
Yes.
My 7-2 has been rejected. I have specifically taken a point that the landlord-tenant relationship was disputed because the plaintiff claims to be a subsequent purchaser and no letter of atonement was ever served upon me. And
that cannot be a ground.
That is admitted, Your Lordship.
What admitted?
That no letter of atonement was served. But since I was not informed, never I was informed, I have specifically, they have exhibited a document, a letter, where my learned advocate in the year 2015, prior to filing of the suit, has intimated them that kindly supply us the document of your deed or the information that who is the landlord and the mode of payment which I have to do. That is annexed at page 82. This is exhibit number 4. They have exhibited this document and they say that I had adequate knowledge regarding the sale and as such I am not entitled to the protection, and the learned judge has proceeded that I have not complied 7-1 and as such I am not entitled to the protection under the West Bengal Premises Tenancy Act, and thereafter proceeded to allow 7-3.
Mr. Chatterjee, if you have when the suit property was purchased by this
the sale deed they have annexed, Your Lordship, that is 2014.
So when did you last pay rent?
2014.
Why? You could have paid rent to the because the owner, you did not knew about this purchase.
No, I tried. My case
so
is
you never knew about this purchase.
No, I learned it in 2015 and immediately
so
thereafter.
From in 2015, what you did from 2014 to 2015?
I was not paying. My case is that, Your Lordship, the rent controller was not there, but I could not verify this.
No, did you, any documents that you have sent rent to the erstwhile landlord? No.
I have made that statement. I have made that statement.
Where is the document that you have sent money order to the thereafter rent controller? Show me those statements.
But Your Lordship, even if I take it that there are arrears, but I am supposed to deposit that at that, I may deposit that at the time of filing of my 7.2 application as well.
Yes. So what prevented you from depositing that?
What I am saying is that since I am not aware that now, Your Lordship,
The Chatterjee, you are aware.
several
It's a
parts.
sham dispute which you are
No, Your Lordship.
Yes.
Because
Yes, Mr. Chatterjee, if
Your Lordship,
yes, you were not aware,
my letter.
you could have paid to the erstwhile landlord.
I
You
tried.
knew
That is my
everything.
amendment. There is my amendment in
So you
7.
knew everything. That
Lordship, kindly take a look at page 82, my letter. This is their exhibited document. I say paragraph 2, Your Lordship kindly sees that my client reports to me that he came to know from one Nimai Gorai that you have purchased the same, but neither landlord of my client nor you ever informed my client till date. That my client states to me that he is ready to pay monthly rent to you. As such, you are requested to supply a copy
these
of
are the findings, Mr. Chatterjee. What I was telling to you, same is finding. In his deposition, we went to give rent to Chatterjee, but it was not received. Further admitted he did not send rent to the money order in respect of the rent. So you have admitted all these facts. On perusal of DW1, the 8th of June, it is found that admitted the plaintiff has, he admitted that plaintiff has purchased by way of a deed, being number such and such. He
because from the
stated
sale
that
deed-
not a fact, I have never paid rent to the plaintiff after
from the sale
plaintiff
deeds
has filed a certified copy as per the defendant was bound to pay to the landlord all areas. Though admitted in his deposition that the plaintiff's owner, he has not paid rent since, but he neither deposited the areas of rent.
under 7 months. And another thing, Your Lordship, from the sale deeds also, Your Lordship will find there is not a single word regarding transfer of the tenanted property. What portion was actually sold? I do not know the entire measurement of the
We'll know when
property.
the decree will be passed. Then he will know.
Your Lordship, kindly.
Then he will
see
know
the-
what is the
kindly
extent.
sees the sale deeds also. I have annexed those.
Yes.
Your Lordship, kindly sees page 59 is, there are 2 sale deeds.
Yes.
Page 59 is one schedule, the last paragraph. There is the third line of the last paragraph, তৎপরিচিত 900 বর্গফুটের পাকা গৃহাদি. But the deed never describes that the tenanted portion is within this 900 square feet. There is nothing. And another deed is also there at
Mr.
page
Chatterjee accepted. Your tenanted premises was not purchased.
Maybe
Accepted.
that is my contention.
Yes, yes.
Maybe.
I accepting your contention. Then the erstwhile landlord is the owner. So you have not paid rent to him.
But Your Lordship, if the landlord today,
You have
the
not paid
landlord
rent to
files
him.
a suit, if my erstwhile landlord today files a suit, I have to, it is my liability to deposit the area rent. But any person who claims to be a landlord, if he comes, I have to tender rent in each and every suit. That, in my respective submission, is not the provision of 7.
Show me your deposition.
Yes, Your Lordship.
Show me your deposition.
Thanks. My deposition starts at page 41 is the chief. My cross.
No, your cross.
Yes, cross
Show
at
me your
page
cross.
44, Your Lordship. The affidavit in chief was written as per direction of learned advocate, not that I cannot tell what is written in my affidavit in chief. Later volunteered, I told my learned advocate about such and such, and I am contesting the suit. This is the notice for eviction of 2017. I cannot say whether Dinesh Gupta is the owner of the suit property or not. I cannot read and write Bengali and English very well. Not that I am tenant under Dinesh Gupta in the suit shop. I am tenant under one lady having surname Chatterjee. I have stated the full name in my 7.2. I cannot recall her name. I cannot recollect the amount of monthly rent. It is a fact that after June 2014, I went to give rent, but it was not received. I went to give rent to Chatterjee. I did not send any money order for rent. I cannot say on which date I have filed a petition under 7.2. It is fact that after June 2014, rent of the suit shop has not been deposited. I would file rent receipts to show that I am tenant under landlady Chatterjee. And thereafter deferred. I am a retired person. I have retired in the year 2007.
The fourth line, I do not know whether landlord has filed this suit for eviction or not. I cannot say whether the landlord has issued notice through learned advocate prior to institution of the present suit. I do not know whether I have replied to the said notice or not. I have paid rent
Yes,
to the suit
yes,
property.
this is your admission.
Lordship, I have
I know Dinesh Gupta is the present plaintiff.
landlord, your lordship,
Yes, I know that Dinesh Gupta purchased the suit property by way of deeds being number such and such of the year 2014.
But your lordship, whether that constitutes a admission at the stage
Yes,
of the,
has to.
your lordship kindly considers this, because no letter of atonement. I specifically wrote to them.
Mr. Chatterjee, if you know a fact, letter of atonement is nothing. This
Whether
application
the
under
suit property, because this was, your lordship, I have taken instruction from my learned counterpart. What transpired is that it was told that it was a building. So whether you know that the building has been purchased, it has been. Lordship kindly considers this. May I come back, your lordship? Because
thank you. This application,
because under your lordship, 1 minute, your lordship. Because if there are areas, the learned trial court has to decide that issue. What is the area and who is my landlord? When the relationship,
provided you have deposited the admitted rent.
no, admitted to the landlord. I do not admit him as my landlord, your lordship. That is my contention.
Here it is being admitted. Here I am on your deposition.
Lordship, then kindly cease their deposition.
Your deposition, you know.
Your
What is their deposition?
Lordship,
They have said that you do not know. Show me.
They have admitted that it has to be adjudicated under 7.2. The issue has to be admitted.
Yes,
that is their admission.
adjudicated, no dispute. But the fact remains.
Your lordship, ultimately
provided you pay
7.1
the admitted amount.
Your lordship has the learned trial court has proceeded under 7.1, non-compliance of 7.1, not
Yes.
on the issue of 7.
7.1 areas also you have to pay.
That is
7.1 areas you have to deposit.
where the landlord is admitted.
Mr. Chatterjee, it's not 7.1. Now it's 7.2. Because you are challenging the relationship.
Yes.
If you have challenged the relationship, it has to be 7.2.
Yes, I have.
7.2 is
application
rejected, not
ultimately.
7.1.
But the finding is that non-compliance of 7.1. Your lordship kindly sees the impugned order. From internal page 2, the last paragraph. The learned trial court has proceeded on the basis of 7.1, that I have not complied with 7.1. But the issue of landlord-tenant relationship.
This application under Article 2.
The disputes mentioned therein, as per provision of 7.2, the defendant is not required to pay or deposit current rent. It is therefore graciously pleased. That is only the contention of 7.1. I have not admitted or stated anything. I have only stated that the dispute is under 7.2 and I have filed 7.2. Both the applications were filed on the same date.
And on this, what order was passed? 7.1?
7.1, your lordship will find order number 2, the first certified copy, first order, 27 July 2018. that was allowed provisionally, and I was directed to pay under 7.1.
You ought to have challenged this order.
I have,
20
I have.
Not in 2025.
Because I have, I have
2018 order.
filed an application under 151 praying for that.
When you have accepted this order.
This order may be kept in abeyance till
Where is
adjudication.
that?
Yes, I have an extra. 33.
Page
33.
No, that is your application, Mr. Chatterjee.
But keeping it in abeyance, and that
Where
was
is the
kept,
order that it has been kept?
that was kept pending. That application has not been. I have
All right.
specifically averred your lordship in the revisional.
This equivalent
That was kept
under
pending.
Article 227 of the Constitution of India is at the instance of the defendant Number 29. Yes.
Yes, in a miscellaneous case under Order 9, Rule 13, my lord. My lord.
Allowed?
No, my lord, what happened on the 95th day, the second date for filing written objection. My lord, my lord, objection is ready, my lord. But my lord, due to inconvenience of the my lord plaintiff, he could not turn up on that day. 1 week accommodation was sought for. That was turned down.
Miscellaneous case, Order 9, Rule 9 or Order 9,
Rule 13, Rule 13. My lord, kindly have a look at first that what is the basic of filing that Order 9, Rule 13 application. In his application, he has stated, my lord, kindly have a look. He entered appearance in the suit after having summons. He filed written statement. Thereafter, he took no steps and consequently the suit was decreed expert. My lord, so my lord, what is the ground of
occasions you have paid for time?
My lord,
14th of May 2025, you have paid for time.
It was ready on that day. It was ready, my lord.
But you have paid for time.
Yes,
2nd of June also you have paid for
that
time.
is true. It is not exceeded 120 days, only 95 days, my lord. It is mandatory, not mandatory, my directory, my lord. My lord, Koilas versus Nanku, my lord, it was my lord, decided, my lord. So, my lord,
by
12 9, we are, my lord,
by the order impugned.
On that time, ready.
You have yourself said that he will not be put the decree into execution.
But
so
if it is state from this honorable court,
yes,
it will be, my lord, it will be, my lord.
will be delaying the miscellaneous case and will be putting this decree.
My lord, but can fix our listed motion? I am serving and come within the 40, within the
All right,
45.
no problem. Yes, next matter, call the next matter.
But item number 30, I am for the petitioner. My lordship has directed me to produce the deed which was impounded by the order.
Yes.
My counterpart in the court bill is in Chennai for his treatment. Well, kindly give me some.
After vacation.
After vacation?
How much time?
September.
On the prayer of Mr. Ghosh, learned advocate.
Last order আছে.
Yes, yes. Who is appearing?
I am appearing on behalf of the petitioner, my lord. I am the plaintiff in the suit, my lord.
Yes, who is appearing for the parties in the Baripur court?
Yes, my lord, I have instructed on the other side, my lord, learned advocate, Mr. Chinmoy Chakraborty is appearing, my lord.
And
For the court, learned court below. And for the plaintiff, my lord, Mr. Musharraf Hussain Khan is appearing for the plaintiff, my lord.
Yes, I do not have any difficulty in taking up.
Absolutely no.
Yes, yes.
My lord,
What is this matter?
this application is filed, my lord, challenging order number 22 dated 30th June 2025, my lord. An order was passed, my lord, by the learned court below for the local inspection by a commissioner, my lord.
Yes.
But my lord, the defendant number 1, my lord, is saying in his application before the learned court below, my lord, that there is a shop room of the plaintiff. But the plaintiff is claiming, my lord, that there is no shop room over the suit property, my lord. Without survey, my lord, the order of local inspection was passed, my lord.
What is the suit for?
The suit for declaration, declaration, partition, and permanent injunction.
Declaration, partition, and permanent injunction.
Yes, my lord.
Show me the application for local inspection.
My lord.
Where is the application for local inspection?
Not at page 47, my lord.
47.
At 47, my lord. 47 and 49.
Yes. What is the difficulty?
You know, the difficulty,
Inspection that is in aid of this application.
my lord, the difficulty is, my lord, the defendant number 1 is claiming that there is a shop room situated of the plaintiff. But my lord, the plaintiff is claiming that the shop room is situated, but not over the suit property. My lord, first, my lord, the survey.
Only whether the local inspection was paid for, because they have said that for the purpose of safety and security it is necessary. Report will come that will
Also, my lord, kindly see the kindly come, my lord,
yes,
the
this
page
application
40
under Article 227.
to appear on behalf of the petitioner.
Yes.
But I have.
Yes.
This is civil divisional application directed against an order of the learned Wakaf Tribunal extending the time specified in this notice under section 54(1). That is my only grievance. The notice under section 54(1) was under challenge before the Wakaf Tribunal under section 83(2). Malad, it was argued that it is not an order, it cannot be amenable to challenge under 83(2), section 83(2). Malad, although that was turned down, Malad, a line was added just at the last portion of the order, Malad, saying that the order which was there, Malad, kindly comes to the impugned order, the order in portion, the last portion.
Yes.
But the direction is hereby given to the board of Wakaf to avail the copy of the complaint of the complainant to the applicant for the purpose of taking preparation to defend the proceedings running before the board of Wakaf if proceedings of the same has not been already reached at final adjudication and conclusion before the board of Wakaf in respect of the same notice. Could not have done this, my lord, because the date specified in the notice was 13th of April. My lord, I'll give your lordship the dates. The notice under section 54(1) was issued on 15th of March 2023. They have received the notice on 17th of March 2023. 13th of April was the date specified within which they were to file their reply to the show cause notice under section 54(1), which they did not. And they filed this OA application before the Wakaf Tribunal on 13th of 17th of April.
Your submission was that you have not given the copies of those complaint. That
Yes,
was
sir.
your submission.
That was turned down.
No, that has been allowed. Board of Wakaf to avail
To
the
extend-
direction. Yes, copy of the complaint. That was your grievance.
My lord, kindly comes to the 54 notice for once. And I'll show your lordship what the provision says as well.
54 notice, but this was your submission that you did not have the complaint so that you could not give an effective reply. That is the submission recorded.
The
That is the
contention-
submission recorded. Please kindly come to internal page 4 of the order, last paragraph.
Yes, my lord.
Yes. CEO has issued a show cause notice letter such and
Yes.
such. The power given to the CTO
Well,
to act in terms of the complaint and to initiate. Obviously, an independent, the grievance raised by the petitioners is that when CEO has sent notice to the applicant,
That was not, my lord, I was not the petitioner in OA application. It is the opposite parties who are the petitioners.
Yes.
They, my lord, kindly visualize as one thing. They are the alleged encroachers. I am the mutwalli of the property.
Yes.
My lord, 54 notice was issued against them. My lord, they had challenged the notice and filed this instant application under 83(2).
Yes.
Challenging the notice. With respect to that, the tribunal has held that the notice under section 54(1) of the Wakaf Act cannot be the subject matter of challenge under 83(2) because it was argued that the notice cannot be construed to be an order.
Show me your submissions.
Yes, my lord.
Before the tribunal.
My lord, my submissions before the tribunal is, my lord will kindly looks to page number 3, last paragraph.
Yes.
Starts from there, my lord.
Yes.
My
Per
lord, it's
contra.
Per contra.
Yes.
The learned counsel for respond number 1, my lord, I have cited several judgments, my lord. My lord has passed a judgment, my lord, that Hooghly building judgment, where my lord section 54 notice was under challenge. So my lord has stated clearly that section 54 is a code in itself and no interference can be warranted by any tribunal or any court. It has to be followed in toto, and section 54 says it all. My lord, there is a procedure laid down under section 54 which has to be strictly adhered to and followed. The tribunal has interfered now. Why I say this, my lord? If my lord kindly comes to the impugned notice which was under challenge. This is indeed, my lord, in my respectful submission, an arguable case, my lord.
The proceeding before the Board of Waqf is still pending.
Pending.
Yes.
Pending. My lord,
So
kindly
it's still pending. Now, your complaint, their allegation was that they were not provided with the copy of your complaint.
My lord, need not at all, because under 54 the notice is enough. The notice states the ground. Kindly comes to the notice for once, page 58. Page 58 is the notice.
So according to you, they are not entitled to a copy of the complaint.
If no, they are not. I am not saying that, my lord.
That is the only direction which has been passed. Your complaint, they will have to be provided, and the proceedings before the Board of Waqf is still pending.
Cannot, because my lord.
Is it pending or it has been disposed of?
It is pending, my lord. It is
Yes.
pending. It is still pending.
Yes.
Kindly hears me.
So it has, it is not required that that proceeding is to be disposed of.
Lord, it is required that the proceeding is to be
Yes, so
disposed of.
it has been only directed that.
No, cannot direct, my lord. In my respectful and humble submission, cannot be directed in that manner. Kindly comes to page 17 for once.
17.
17.
Yes.
17, my lord, kindly looks to the second paragraph of the notice.
Yes.
Accordingly, in exercise of power conferred on me under section 54 of the Waqf Act 1995, I do hereby direct you to show cause with evidence in support of your claim by 13th of April 2023. They have failed to do so. My lord, just to dodge this, my lord, they have filed this OA application, and the liberty was given extending this time. Section 54 does not permit, my lord. Kindly takes up section 54 for once.
Yes.
Lord, this is the new act, but there is no changes in section 54. Lord, section 54(1). My lord, and what has fallen from your lordship is that I need to make him, the alleged encroacher, a copy of the complaint that was also given by the Mutwalli to the CEO, on the basis of which this 54 application was given.
Yes, 54(1).
Yes, my lord. Whenever the chief executive officer considers whether on receiving any complaint or on his own motion that there has been an encroachment on any land, building, space or other property which is a Waqf property and which has been registered as such under this act, he shall cause to be served upon the encroacher a notice specifying the particulars of encroachment. So, my lord, it has been specified, and calling upon him to show cause before a date to be specified in such notice. This is the date which has been specified in the notice. As to why an order requiring him to remove the encroachment before the date so specified should not be made, and shall also send a copy of such notice to the concerned Mutwalli. My lord, now kindly comes to subsection 3. If after considering the objection received during the period specified in the notice, so the reply to the show cause has to be within the period which has been specified in the notice and not beyond that. And it is his categorical admission in the OA application as well that he has received 2 days just after the notice was issued. My lord, a person who was sleeping over his rights cannot be allowed to.
So according to you, if the reply to the show cause notice is not filed within that time,
in that specified time, it's gone. He has missed the bus.
Show me that how this you have raised that point and how it was decided.
My lord,
show me that.
I did not raise this point because, my lord, kindly appreciates one thing. This point was never argued. This was an observation. My lord, kindly looks it into the impute.
According to you, this under section 54(1), this time could not have been extended.
Could not have been extended.
Yes. So show me that you have raised that point.
My lord, I did not even know that this order could have been passed because this was not the case at all. My lord, kindly sees the OA application as.
Yes, show me the OA application.
My lord, the OA application is at page 19.
Yes.
19.
Yes.
My lord, they have not even made out a case that the time can be extended. Kindly looks into the prayers as well. They have just prayed for cancellation of this notice, setting aside of this notice.
Yes.
My lord, the prayers cannot be molded in this manner when the provision is not allowing. Provision does not allow, and the interference of the tribunal is only after the CEO has passed an order.
That has to be because the show cause notice has to be replied. Then the chief
within the specified time.
Chief executive officer has to arrive at a finding whether it's a Waqf property and if there is an encroachment. If the CEO arrives at a finding that it's a there has been encroachment, CEO cannot do anything, it has to be referred to the tribunal.
Has to be.
Has
has
to
to
be.
be.
So there is no dispute
Because-
with regard to that.
Because
So now they, according to them, they have challenged this notice before the tribunal.
my lord,
They have challenged before this notice.
yes, my lord. In 2023, they have challenged the notice
Yes.
after 13th of April. This is my only contention. This is where the problem lies, my lord. If they would have come before 13th of April, I could have understood.
Show me that you have raised that point that this cannot be challenged after 13th of April. Show me.
My
You
lord,
have not raised that point.
I have
Show
raised
me.
this point, my lord, because
Show me that you have raised that point and how it was dealt with.
this paragraph, this very paragraph which was inserted after the order in portion, that was not at all argued. That was not at all
What
the
you have,
point.
please show me what you have argued.
My lord, kindly.
Come
My
at
lord,
2 p.m.
What I have argued is that.
Come at 2 p.m.
Very well, my lord. I shall come at.
Show me that you have raised this point and how it was dealt with.
Very well. I shall.
Take this.
My lord can keep it with you, my lord. Very well, my lord. I shall again give it.
call the 2 p.m.
32
PM matter.
32 শেষ হয়নি
2 p.m. Please wait, there is a 2 p.m. Order যেটা ছিল
6.
item number 6
I'm for the opposite party.
Accordingly, the judgment and order dated 18th
Urgent Xerox 35.
that has been provided. Party the yes. Yes.
May please your lordship, my lord.
Yes.
That this is the Wakaf Act that I'm handing over. That was the new act. This is the old act, my lord. Lord, may I take some time to just to refresh your lordship's memory, my lord? Just some time. I'll just assist your lordship with the dates first. That is very important. With regard to whatever I'll argue, my
The
lord.
original application before the tribunal,
My lord.
that was rejected.
Rejected.
So how are you affected by this?
My lord,
Because they had challenged, your submission is that the
this
notice
is why
and
I'm
the
saying that, my lord, let me take your lordship to the first the dates. The dates are very important, my lord. Very important.
Yes.
My lord. My lord, the section 54(1) notice was issued on 15th of March 2023. 15th of March 2023, the 54 notice was issued, asking them to come before the board and file a reply to the show cause as to why they are not the encroachers. If they fail within the specified date, then they will be evicted. This was the condition, and this is the statute also says so, my lord. 17th August, it is the categorical admission in the OA application itself, my lord. On 17th of March, that they have received the notice under section 54(1). My lord, the admission is at page 25.
17th of March, notice received.
Yes, my lord, 2023.
Yes.
17th of March, my lord,
Yes.
that my lord will find at
Alright,
page
then
25.
yes.
Yes, my lord.
Then
On the date specified in the notice is 13th of April 2023.
Yes.
And my lord, they have filed the OA application on 17th of April 2023 after the expiry of the date so specified, my lord.
OA filed.
Yes, my lord. 17th of April 2023, they file an OA application. That is after the date which was specified, after the expiry of that date, my lord. I am on this, my lord. My lord, before that, they have
So according to you, the OA could not have been entertained.
could not have been entertained, and it has been rightly dismissed.
Yes.
But this last paragraph is troubling me. Why? I'll tell your lordship.
Last paragraph says that only the complaint is to be forwarded.
My lord, cannot be. Cannot be, because the section 54 notice in itself is a complaint, which is the only thing which is to be forwarded. Because my lord, 54(1) does not
The
say.
difficulty if you have made a complaint
My lord,
on the basis of this proceeding was initiated. What is the difficulty in
Not-
forwarding that complaint?
There is no difficulty, my lord. There is this order opens the floodgate, my lord.
What floodgate?
If I, my lord, to 2023, I was sent a notice. 2025, I come up and say that, look here, I have not got the complaint. Please give me the complaint. He could have approached. That has been recorded. That has been recorded in the impugned order. They could have approached the learned Wakaf board and asked for the complaint, which they did not do. My lord, kindly
Which
come
they
to-
did not do within the time.
This will open the floodgate, my lord.
What will open the
Because,
floodgate?
my lord,
Nothing will happen. Please supply the
kindly
complaint.
for 2 minutes, sir. Kindly. If I suppose the notice is there, given notice has expired, gone, and then I come up with an OA application to extend the time, my lord, this will harm the expeditious disposal of the application under section 54. That's number one, and that will, it will go against the dictum of the statute itself, which provides for expeditious disposal, my lord, because 54(1), 54(3) says that the tribunal stage, the stage when the tribunal shall interfere is after the CEO has passed an order. That is not the case here, my lord. The tribunal is interfering.
Tribunal has not interfered anything, has not said anything.
Let me
has
serve a
only-
copy and come back,
No, no,
because
only-
this is an important question of law that is to
No
be
question
decided.
of law is involved. Please give all points are left open to be decided by the
The
court.
copies are not to be supplied, actually are not to be supplied, because my lord, I'll appraise your lordship with one thing, just one thing, my lord. Kindly comes to 50.
You are saying if within the time applied for the copy, yes, that could be said.
Visualize
Now you are
the
saying,
same.
yes, that could not have been served.
Kindly visualizes one thing, my lord.
Please show me the complaint. What is there in the complaint?
My lord, complaint I have not annexed. Complaint, this is where I am, my lord. Kindly appreciates this, my lord. The complaint can be in written form, in oral form, as well as the chief executive officer can suo moto draw this application, my lord.
This is not a case of suo moto.
My lord, this is not
a case of
certainly
suo
not,
moto.
my lord.
Yes.
If
So
that-
this is on the basis of a complaint, whether it's on the basis of written or oral complaint. Please
Sir,
satisfy me.
they have the times, the statute
shows
say
when you are shying away from giving the complaint.
shying away, my lord.
There is
The
something.
statute says it, my lord. I am not shying away. The statute says it.
Yes,
Kindly
yes, nothing will be done. Yes.
Section 3, my lord, kindly comes to subsection 3 for once.
Yes.
For once. If after considering the objection received during the period specified in the notice, my lord, the legislature is time and again using the phrase during the period specified in the notice. My lord, there has to be some implication, some importance given to this phrase during the period specified in notice. Without this, my lord, cannot happen, my lord. They have chose to come after the expiry of the period so specified in the notice. Could not have done, because 54 is a complete code in itself, and if 54 says it, if 54 suggests something to be done in some a particular manner, it has to be done in that manner, because
These objections filed beyond time cannot be considered.
No, my lord.
Show me the authority on this. Show me.
Authority, my lord, I don't have, because this is why I am saying, my lord, I could not find any authority.
You will not find any authority on that.
Exactly, my lord. Kindly decides this question, my lord, because this is an important
Ashwin, this
question of law to be
application-
decided.
Number 33 and 34.
তো একসঙ্গে কোথায় উইথ নেই তো
My lord, that matter was argued by Mr. Chatterjee yesterday and my lord kept it for passing the judgment.
Oh,
That order 12 rule 6, man.
order 12 rule 6. All right. Mr. Chatterjee will come tomorrow,
He will be available on Tuesday, my lord.
Tuesday. Acha, this matter.
Grateful.
Yes, next. Yes, call the list.
Then number 35.
The opposite party number 1.
Yes.
I'm for the opposite party number 1. Lord,
Yes.
this is an application by the petitioner. This is a second round of litigation where they have invited the trial court attention to decide on the valuation of the suit, the valuation of on the court fee. So, Lord, on the first round, Lord, they have lost before the learned trial court, preferred the civil revision application. Against this, again, this honorable court was pleased to direct the learned trial judge below to re-decide the fee. Re-decision has been taken place. They have lost. Again, they have come up in the second round of litigation on the self-same point. So, Lord, the res judicata will also apply, Lord. And I'm not finding any petitioner here today. Sir, Jigish
Lordship, after the petitioner lordship, bring for short passover.
No, আমাকে কিছু না।
Where is the plaint?
Lord, plaint is at page number 16. Page number 16, Lord, annexure A starts. Passover charge.
Lordship, I'm praying for short Passover, Lordship. I'm led by Mr. Raghunath Chakraborty.
You're led by?
Yeah, come, Lordship.
Yes. Yes.
One of the defendant is the petitioner before your lordship. Your lordship is a suit for declaration to the effect that a particular lease deed is void, inoperative. That is the principal prayer.
Yes.
Lordship kindly comes to the plaint, prayers of the plaint, which is at page 25.
Yes.
Declaration that the plaintiff is the co-owner in the suit property and therefore entitled to possess. Declaration that the original defendant jointly, severally have no authority to deal. Declaration, important, that the purported lease deed executed and registered by the original defendant in favor of defendant number 2 is a voidable document and not binding on the plaintiff and co-petitioners.
Lease deed is between whom?
But lease deed registered by the original defendant number 1 in favor of defendant number 2.
So executed by defendant number 1 in favor of defendant number 2.
Number 2.
And so plaintiff is not a party to that.
Yes, plaintiff is not the.
So if the plaintiff is not a party to that, he can put in his own valuation.
I tell your lordship. I tell your lordship. Your lordship kindly comes to paragraph 20.
Of the plaint.
Of the plaint.
Yes.
The plaintiff therefore states that the original defendant has committed fraud such and such by executing the said registered lease in favor of defendant number 2 for a period of 99 years upon accepting a paltry sum of rupees 1 crore as premium and 2 crores as security deposit against the market value of the property, nothing less than 50 crores. He says market value of the property is 50 crores. Such execution has been made as stated herein above, behind the back and beyond the knowledge of the plaintiff and other co-petitioners and without their consent. So this is the statement made in the plaint. We referred an application under Order 11 Rule 7B, your lordship, that was rejected. Assailing that order, we preferred
Order 7 Rule 11B, your contention must have been that the suit has to be valued in such and such, it's undervalued, so plaint is to be rejected.
My lord, assailing that, we preferred a revisional application. Your lordship was kind enough to entertain that revisional application. Your lordship kindly comes to
entertain.
My lord, entertain, your lordship have observed, though your lordship have declined to interfere.
Say so, you have said entertain.
My lord, kindly sees the order. My lord, page 60.
Yes.
Page 60. And just not, it appears that the suit has been valued such and such. The learned advocate appearing for the petitioner draws the attention of this court to paragraph 20 of the plaint and submits that it has been admitted by the plaintiff opposite party that the market value of the property is not less than
The consideration under Order 7 Rule 11 is entirely different from a consideration in an application under Section 11 of the Court Fees Act. So, there.
Just a minute.
Yes.
A plaint can be rejected under Order 7 Rule 11B of the Code of Civil Procedure if where the reliefs claimed has been undervalued and the plaintiff, on being required by court to correct the valuation within a time to be fixed by the court, fails to do so. On a query of the court, the learned advocate appearing for the petitioner in such and such, in view of thereof, this court is of the considered view that the stage has not yet reached by invoking the provisions of under Order 7 Rule 11B of the Code of Civil Procedure. Since an objection as to the valuation of the suit has been raised, this court is of the considered view that an opportunity should be granted to the petitioner to file an appropriate application raising an objection.
That you have done.
That we have done.
Yes.
That has been rejected, my lord. The ditto order, my earlier order and this order, almost identical grounds. No inquiry, no finding with regard to the inquiry. Only your lordship.
What inquiry will be made? What inquiry will be made?
But the court only on the
in the plaint, a lease deed has been challenged by a party who is not an executant to that instrument. If that is so, the plaintiff can put his own valuation
that is
in a suit for declaration and injunction.
What is falling from your lordship, that is, my lord, in the plaint he says valuation in such and such.
Valuation of the property. Valuation of the property.
He says a declaration. He is asking for a declaration.
The valuation of a property and valuation of a suit. At times, maybe in certain cases, yes, the valuation of the property has to be, the suit has to be valued in that manner. But show me that in a suit for declaration, that a deed is void, and for a permanent injunction, it is to be valued as with regard to the market value. That's all. It's not that the market value is disputed, but how the suit is to be valued. Show me that the suit is to be valued according to the market value. Yes, then you are right. Show me that. How such a suit is to be valued.
The learned judge, my lord, in view of the judgment, which in my humble submission is not applicable in this particular.
What judgment?
My lord, that Surit Singh.
Surit Singh, non-executant to a deed,
non-executant,
is not required to pay for cancellation. An example given, A to B, whether if it is a executant, what will happen if he is not an executant? And oh yes, that paragraph has been quoted. A executes a B sale deed in favor of C, wants to avoid the sale, A has to sue for cancellation. If B, who is not an executant to the deed, wants to avoid it, he has to sue for declaration. That's the ratio. So that is why I asked you when you are placing the prayers, whether that instrument, plaintiff was an executant.
That is not the plaintiff's case also.
It's not your case also. It's not your case also. If you can show, yes, the plaintiff from their document, he was an executant, or from the document itself, he was the executant.
He is disputing a particular released it, he says that that
Yes,
particular-
paid for declaration, it's void ab initio.
Void.
So then he can put his own
Void
valuation.
and inoperative, almost same thing.
Yes, yes, void inoperative, but he is not required to pay for cancellation. Because even if that instrument is left outstanding, he will not suffer.
But if a
That's the section 31 of the specific relief act. You have to consider that.
If a document itself is a void document, declared it's a void, obviously it cannot be operative. It's automatically it stood cancelled. It stood
Cancellation, section 31, then an specific order is to be passed, it is to be forward. This order has to be forwarded to the registration office for delivering and cancelling of that registered instrument. Though I have reservations, even if a deed is declared to be void, if it is left outstanding, Mr. Mukherjee,
it's difficult at times because not the
because
repository of below all records
yes,
concerning
because it will remain. Now you will purchase that property. You will make a searching from the registered office. You will find that. Then you will purchase. Then he will come. Look, this deed has been declared.
there will be a latent defect because we do not know about the declaration of the property.
But that's the law. We cannot. We cannot
That's the
help
reason,
it.
Lord, for the due diligence, Lord, the court searches are required.
Yes, but if this is the law, once you declare a document to be void, that has to be may not be cancelled. That endorsement, cancellation means there an endorsement will be that it is cancelled.
Endorsements were
So
not
why
done.
not this endorsement that it has been declared as void?
Endorsements were not done in a particular case. In a case of mine,
because this will create.
There was a violation of an injunction order. A particular deed was void. We got searches. No such report. We purchased the property. Ultimately, the deed is void because there is no database maintained.
Get the
in
law
registry
amended.
office.
At
No
the
database maintained in the registry.
Get the law amended by this application under Article 227.
instruction on the defendant to cancel the treaty. We have not invited the court to cancel the treaty. Read entirely.
এই তো ওকে বলেছিলাম দিল না 5,000 টাকা কোর্ট কি দেবে 50 কোটি টাকার মামলা করবে
We are ready to plead provided if it's
like effort করছে he valued the relief sought, so relief sought is also for cancellation, so you have to value your suit according to your relief claim. This relief has been claimed, Mr. Mukherjee. Till now you have not given up your that relief.
But I will just try to but kindly come to 4B. 4B. B.
Yes, I am at 4B.
For declaratory degree and consequential relief, to obtain a declaratory degree or order where consequential relief is paid.
You have paid.
Now, my lord,
in such
in
a
all
suit
such suits, the plaintiff shall state the amount
at which he valued the relief sought. So
I
yes,
value my relief sought at 50,000 rupees.
Cannot.
But I will not be valuing it, my lord, according to the market value of the property.
There are two things.
The market value of the property is a different concept.
No, market value.
I'll just rely on a Supreme Court on this.
Mr. Mukherjee, there is no dispute. Market value is a different thing also. Under this section 7, under certain categories, you have to value the suit according to the market value.
That is
Now,
section 8 of Lord, the
section 7.5.
no,
Section
the
7.5.
Suit Valuation Act, section 8.
No, 7.5 also, you will be
Yes.
finding in under this type of suits, 7.5A.
Yes.
Value the subject matter, value the, so 15 times.
Yes.
So, and recovery of possession, Mr. Mukherjee will be finding that it has to be valued according to the market
Yes.
value.
Yes.
So, that's, it says, if those reliefs are claimed, you have to value according to the market value. That's one thing. Under section 7.4B, you have to value according to the reliefs claimed.
So, my lord,
Now-
that's my own valuation of the relief. It is not based upon or linked to the market value of the property.
But
Because this is the
cancellation,
relief claimed is, my lord, our own assumption of the relief valuation.
cancellation, if you pay for cancellation, Mr. Mukherjee,
Lordship.
then how a cancellation of a document, how such a suit is to be valued for
Lord, here,
cancellation?
Lord, kindly see, Lord, by prayer. Lord, it is a declaration, mandatory injunction calling upon the original defendant number 1 and the defendant number 2 to jointly and or severally return and cancel the lease deed. It is couched in a different language.
Yes,
It is not in the language of, my lord, section 31. It is a declaration and a mandatory injunction upon a party.
Severally return to whom?
Return
Have
and
to
cancel
registration
the
office.
lease dated such and such.
And cancel
But
the
so
lease
the
deed.
deed be thus delivered up and cancelled. So this is, my lord, what I say is, my lord, a declaration pursuant to, my lord, 7.4. Now, my lord, your lordship will kindly see, when your lordship sees, my lord, the judgment of 2010, which has been relied upon by the learned judge. Subsequently, the principle has been, my lord, affirmed by 3 judges of the Supreme Court. Copy দেওয়া আছে? দিয়েছিস? Copy
না, না,
দিয়েছিস?
না, না, না।
No. আমাকে একটা copy দে। সুইচ
নিচে আছে, নিচে আছে।
Paragraph 2. Hold paragraph 2. The learned, the third line. I'm just rushing your lordship, lord, because of the paucity of time.
Yes.
The learned civil judge heard the appellant plaintiff on the question of court fee and made an order dated such and such, holding that the prayers relating to the sale deed amounted to seeking cancellation of the sale deed, and therefore ad valorem court fee was payable on the sale consideration in respect of the sale deeds.
Yes.
Feeling aggrieved, the appellant filed a revision contending that he had paid the court fee under section 7.4C of the Court Fee Act, and that the suit was not for cancellation of any sale deed, and therefore the court fee paid by him was adequate and proper. If the High Court by the impugned order dated such and such dismissed the revision petition, holding that if a decree is granted as sought by the plaintiff, it would amount to cancellation of the sale deeds, and therefore the order of the trial court did not call for interference. The application filed by the appellant for review was dismissed. The application for recalling the order dated such and such was dismissed. Further application for recalling the order was dismissed. Feeling aggrieved, the appellant has filed this appeal by special leave. The limited question that arises for consideration is what is the court fee payable in regard to the prayer for a declaration that the sale deeds were void and not binding on the co-personary, and for the consequential relief of joint possession and injunction. Court fee in the state of Punjab is governed by the Court Fees Act 1870 as amended. Section 6 requires that no document of the kind specified as chargeable in the first to second schedule to the Act shall be filed in any court unless the fee indicated therein is paid. Entry 17(3) of the second schedule requires payment of a court fee of rupees 1950 on plaints in suits to obtain a declaratory degree where no consequential relief is paid. But where the suit is for the declaration and consequential relief of possession and injunction, the court fee thereon is governed under 7(4)(c) of the Act, which provides written down below the provision of the Act. In all such suits, the plaintiff shall state the amount at which he values the relief sought. That is pari material.
Yes. In our case, 7(4)(b) is 7(4)(c).
Yes, it is pari material. We'll
Yes.
just check. Then, the last paragraph of that page, the second proviso to section 7(4) of the Act will apply in this case, and the valuation shall not be less than the value of the property calculated in the manner provided for by clause 5 of the said section. The clause 5 provides that where the relief is in regard to agricultural land, court fee should be reckoned with reference to the revenue payable under clause A to D thereof. And where the relief in regard to houses, court fee shall be on the market value of the houses under clause E thereof. Where the executant of a deed wants it to be annulled, he has to seek cancellation of the deed. But if a non-executant seeks annulment of a deed, he has to seek a declaration that the deed is invalid or non-est or illegal or that is not binding on him. The difference between a prayer for cancellation and declaration in regard to a deed of transfer conveyance can be brought out by the following illustration relating to A and B, two brothers. A executes a sale deed in favor of C. Subsequently, A wants to avoid the sale. A has to sue for cancellation of the deed. On the other hand, if B, who is not the executant of the deed, wants to avoid it, he has to sue for a declaration that the deed executed by A is invalid, void, non-est, illegal, and is not bound by it.
Can we come to paragraph 7?
Yes, I'll come to that, Lord. I'll come to that.
In paragraph 6, those explanations, there is no dispute with regard to that. But the distinction is that paragraph 7.
I'm coming to that. In essence, both may be suing to have the deed set aside or declared non-binding.
Yes.
But the form is different and court fee is also different.
Yes.
If A, the executant of the deed, seeks cancellation of the deed, he has to pay ad valorem court fee on the consideration stated of the sale deed. This is A. A is the executant.
Yes, yes.
If B, who is non-executant, is in possession and sues for a declaration that the deed is null and void and does not bind him or his share, he has to merely pay a fixed court fee of rupees 1950 under article such and such, second schedule of the Act. But if B, a non-executant, is not in possession and he seeks not only a declaration that the sale deed is invalid, but also consequential relief of possession, he has to pay an ad valorem court fee as provided under section such and such. Section such and such provides, in suit for declaratory degree with consequential relief, the court fee shall be computed according to the amount at which the relief sought is valued in the plain. The proviso thereto makes it clear that where the suit for declaratory degree with consequential relief is with reference to any
Here we do not have that proviso.
Here, in 5, my lord, your lordship will find there's a different section is there. That is 7(5).
Yes, 7(5) also that
possession.
Yes, possession is a different thing. Here you have not claimed for possession because your prayer is for injunction. So now kindly come to paragraph 7.
Yes. In this case, where there is no prayer for cancellation of the sale deeds, the prayer is for declaration that the deeds do not bind the co-personary and for joint possession. The plaintiff in the suit was not the executant of the sale deeds. Therefore, the court fee was computable under 7
Mr. Mukherjee, here
of the Act.
In this matter, in this case, what happened? There was no prayer for cancellation. The learned trial judge held that the declaration that it's a void is in effect amounts to cancellation. On that, the trial court said, yes, you have to value the suit according to the market value. The Honorable Supreme Court says, no, you cannot say that it is in effect because there is no prayer. But here you have prayed for that. That's the distinction. You may say that was not necessary, but you have prayed for that. Still that prayer is
But
Yeah.
I will just try to, Lord, apprise your lordship. Lord, whatever, if I make a prayer which is not, Lord, grantable to me, pursuant to, Lord, the direction of this honorable court.
What prevented you from amending this?
Lord, there are a lot of, Lord, prayers made in a plaint which are generally not granted by the court. But here, Lord, your lordship goes by the substance.
What the court will grant, what the court will not grant, let us assume court may also grant. May also grant. You do not know at this stage because there is a prayer. Whether the court fees will depend upon whether the court will ultimately pass a decree or not. Let us assume that you file a suit for recovery of possession. You are valuing it at a market value. Court is not granting you that relief. Do you mean to say, so it is not dependent on what the court will grant, but how you have framed your suit? That's important for the
just, Lord,
purpose
try
of...
to, Lord, put my argument in a manner that, Lord, if it is under 31,
if you want, I can fix this matter, Mr.
Lord, it will be just, Lord, over. If it is under 31, yes, Lord, I have to pay the ad valorem. If, Lord, 31 is not applicable in this case, it is only 34 which is applicable. I am not, Lord, bound to pay the ad valorem.
According to you, you have applied 31.
Lord, whatever I have applied is, Lord, immaterial. The question here is whether I am not going by the fact that whether I am an executant or non-executant.
Are you giving up your prayer for cancellation?
But I'll just not take instruction on that. এটাই তো sufficient ছিল. Why do you couch so many prayers? The change brief doesn't make anything. Lord, kindly see the prayer is sufficient for the purpose.
Mr. Mukherjee, I cannot say that. It's after all you. You have to take a decision how to frame your suit.
But I'll come back, Lord, with the instruction. I think I'll give up, Lord, this prayer. Because, Lord, the prayer in Lord E is sufficient. And that is, Lord, that covers, Lord, the judge. It's a declaration that he is asking for. The declaration that the purported lease deed executed and registered by the original defendant number 1 in favor of defendant number 2 is a voidable document and not binding on the plaintiff and other co-persons.
Because
That's
paragraph F is creating a problem. That's the distinctive features from
I will take
Sunit Singh. Because Sunit Singh proceeded, there is no prayer. That's the specific. You may be right, Mr. Mukherjee, that you are not required to. But now you are paid. Maybe for a person, nobody knows what's the purpose for making that prayer.
I will not. I can also rely upon 2 other 3 judgment of the Supreme Court, Lord, affirming the principle of Sunit Singh.
I'm not disputing, Mr. Mukherjee.
And Lord, there the question about the market value and Lord, the prayers and all were got into by the Supreme
Court. There is no dispute to this proposition. I'm not disputing this. But the only fact is this prayer.
I'll not take instruction whether
it's creating a problem. If you frame your suit in such a way, then you have to value according to the reliefs. This is also one of the reliefs.
But,
and in a case of cancellation, you have to value according to the value of the property. So then it's a different thing.
But I'll come back with an instruction tomorrow about Lord, whether I press for this Lord, the prayer F.
You have also not pointed out this prayer. Because while I was going through dictating that what are the prayers, otherwise I would have passed a wrong order.
Lord, in fact, Lord, in my respectful submission, Lord, prayer F, Lord, that doesn't turn around, Lord, anywhere, Lord, concerning, Lord, the payability of the court fee on the ad valorem.
It is also one of the relief.
Because, Lord, it depends upon the status of the plaintiff.
Mr. Mukherjee, let us suppose prayer F is maintained all through and granted also.
Lord,
then
that will be in the nature of a declaration.
No.
That is not in the nature of Lord under section 31.
Declaration jointly, severally to return.
Only Lord, the language there is a difference. But all that the court
thus delivered up and cancelled. Maybe first part, second part, so much so that the deed be thus delivered up and cancelled. So this is in effect is 31.
But this is couching of Lord a particular prayer in a particular language.
Not being happily worded, but last part is delivering and cancellation. That has to be by the registration of it. Nobody registered instrument, the parties cannot cancel. has to be after the
After the
declaration.
order of the court, it has to be, my lord, that is a ministerial act.
That is a ministerial act. So this is and thus delivered. So language is of 31. Same language.
But I'll-
Specific language is similar to section 31.
আচ্ছা, থাকলে ছিল কি? স্যারের কাছে আছে।
ওটা সেন্টার পাননি পেয়েছেন? Delivered up and cancelled. That's the language. Same language in your prayer.
And court may in its discretion.
Yes. To adjudge it and order it
Go
to be.
adjudge it and order it to be delivered up and cancelled.
Yes. So the court will pass an order. Yes, you deliver it with a direction that be cancelled. It has to be because please see subsection 2 has been registered. The court shall also send a copy of its decree. So there is a such officer shall note on the copy of the instrument. That's the noting.
That is not the
So
direction.
it has to be done. So court will pass this order, then forward this order to the registration office. Registration office will make that endorsement.
But subsection 2, there is no blood prayer required. That is not the obligation of the.
There's a prayer required.
But
That
so
is
far
why.
as one is concerned,
Yes.
that is not in its discretion. So adjudge it and order it to be
So
delivered.
court
up
will
and
adjudge. Yes. So this is to be delivered and cancelled. And this order will be forwarded for the registration office to make that endorsement. They will only make that endorsement of this order. So the order will only be forwarded, not prayer needed. You may pray, you may not pray. But even if you do not pray,
This obligation is there.
subsection 2 is the court's duty to forward, even if there is no prayer. Court has to adjudge it and then it has to be sent.
But here, blood, the question is, blood, having regard to the status of the plaintiff, blood, whether, blood, the court fee is payable according to 7(4) C or not,
7(4)
or B.
No,
yeah,
B,
it is
B,
B
it's
in my
B.
case.
It's B, no dispute. But B also consequential. If you have said this to be consequential, you have also to value at this. Because each and every item, Mr. Mukherjee, you have to value it. Mandatory injunction also you have to value.
That is
Permanent
what I-
injunction.
that is a
Yes, so every reliefs which you claim, you have to value it.
Lord.
So if it is also a relief for delivering up and cancellation, that has to be valued. Subject to correction, that has not been valued here. So if you maintain that relief,
Lord.
then you also have to value it. And cancellation has to be valued according to the valuation of the property. That's what Sudhit Singh says. If it is cancellation.
And in this particular case, in the concise statement, only a statement.
Now you are saying this.
No, well, at this particular concise statement, valuation, simple, no particulars, declaration, injunction, valued as ₹50,000. It must be declaration for
But I'll
valuation.
come back tomorrow with an instruction.
কালকে রে আছে? Tomorrow?
But, he says on Monday. I do not know, blood, why.
আচ্ছা ঠিক আছে
Auspicious day.
I don't know.
পুরো backup আছে সেই জন্য রিকোয়েস্ট করছিল
Maybe on
সোমবার-
Monday.
সোমবার কি অবস্থা? Since you take it in writing.
I'll take it.
In writing.
I'll take it.
Because you are giving up a prayer. If you
Lord.
so please don't take it.
Either I pay 50,000 rupees or I delete one of the prayer.
Pastor, this
That is the court fee of 50,000 rupees maximum. They are fighting for a property of 50 crores.
Yes. So no, there will be other facts also. Court fee may be 50,000. But the thing is that valuation, the jurisdiction of the court.
Court's jurisdiction.
Court's jurisdiction,
Civil judge senior
that will
decision.
also change. It might be a case of return of claim.
Yes, but even that be so, Lord, it will proceed from the stage.
Maybe you are thinking in the terms of court fees, but with regard to the valuation, court's jurisdiction, everything will change.
In the stage of PW1.
No.
If it goes, Lord, to the other.
That's a different thing altogether, but everything with regard to that, court fees, everything will change.
But there is a categorical judgment your lordship knows from the stage where it had
No,
reached in the last.
those are there, but changing, return and
That
other
will take
things.
some time. That will take some time.
So
Let me see, Lord, in which way the instruction comes. If it is for giving up, Lord, the prayer, then, Lord, I'll take it in writing.
has to be, because don't put it on, you may be saved by saying on instructions, but don't put him into embarrassment, further trouble.
Lordship.
Please see to that.
Lordship.
After some argument,
Court fees.
court fees. আমাদের court fees act নেই? আছে তো? Yes, call the next matter.
Monthly list, item number 1285.
Yes.
I'm appearing for the petitioner. I'm on behalf of Mr. Haradon Mondol. He's engaged in court number 10. Kindly a short
No
pass
short
over.
passover, madam, please start. Fixed matters is difficult.
Actually, I'm not aware of it.
On the prayer of the learned advocate for the petitioner hearing of the
Grateful.
Item number 1263.
And for the petitioner,
So there are two matters.
Two matters. On the last occasion, your lordship, because of the view, my lord, of sending the matter to somebody, a mediator, having knowledge of accounting. We proposed Mr. Chandan. Lord, what happened? I'll just not indicate to your lordship.
Oh, this is alimony.
Alimony, husband, wife,
Quantum of
both preferred. Both of them are preferred, my lord. I have preferred for enhancement. He is saying, my lord, that the total income of the year 2017-18 has not been considered, or 13-14 not considered, so it should.
And also, my lord,
What is the stage of the suit?
Suit, my lord,
2012 suit.
They are not.
2012 suit, my
They are not
suit.
making payment. 75 lakhs due.
The ultimate aim is
No,
not
aim
to
is
drag
to
the
get
suit
calculated.
and extract money. That's
is-
the only
may-
not
may-
aim
may-
of the
may-
Mr. Korbukar and Mr. Banerjee, can you not come to a consensus with regard to this? Otherwise, everything will get delayed.
For him to
That
take
is,
instruction, that he-
please, because pay of the amount, I will expedite the suit.
No, there is no difficulty in, if I have to pay, I have to pay. There is no turning back on that. Now, my lord, what I had indicated to your lordship on the last occasion, Lord, that was with respect to, Lord, the trial court has proceeded that today she is entitled to 80,000 rupees. So it
No,
relates
before
back
going to
from
very much, your lordship
2013.
directed him to take instruction for mediation.
Well, Lord, may I explain
Very
myself?
difficult on-
May I explain myself? Lord, the issue is today, suppose she is entitled to 80,000 and that has to relate back to, Lord,
No, that Mr.
2013.
Kormukar, Mr. Banerjee has fairly submitted.
That aspect,
That,
Lord,
yes, that he has
taken care.
submitted. So we can,
Very.
yes, we can make it a something of a sort. So from that is no difficult.
Now, Lord, the other aspect of the matter, that is, Lord, from the documents available, Lord, your lordship would find, Lord, she was earning, she is earning, and Lord, that portion of amount, Lord, has not been, Lord, disclosed properly.
Income from income.
That's the reason why, Lord, your lordship wanted, Lord, someone to be appointed so that the accounts may be scrutinized. But the one thing that fell from your lordship on the last occasion, that is Mr. Banerjee had indicated that certain amounts of money were being transferred to, Lord, the relatives. That portion, I've taken instruction on that. Lord, with respect to that, Lord, my client is in a position to produce their income tax returns also, where it will be shown that, Lord, loans were taken, personal loans were taken, and those were being refunded. That's the only thing.
The money coming to their account, that has to be explained. More than 1.5 crore, 1.75
Mr.
crore.
Kormokar, that's a different thing altogether. One thing, what you are paying, that cannot be deducted because your income, from the income, you may have several liabilities. So you are paying off that. The question is, what comes in your account is your income.
Lord, I have
so whether those have been taken into account for the purpose of computation of the income.
Lord, one thing, Lord, I have been taking care of, Lord, my son, Lord, throughout.
You have been?
I have been taking care of my son throughout. Taking care in the sense, Lord, expenses.
Only school fees,
Expenses.
That is not
Till date, he is major.
School fees, he or she.
Now he is in college.
Studying?
Now
in IIM. In IIM.
That course fee only.
Entire I am paying. The hostel fees I am paying.
Apart from
what? Lord, he's a major. He's a major. I am
Mr.
undertaking
Kormokar,
all
after all,
expenses.
Mr. Kormokar, after all, he is your son.
I am doing that.
So major means he's not earning, Mr.
That's
Kormokar.
the reason
What
I'm
you are
doing that.
Major is a different thing
That's the
altogether.
reason I'm doing that.
You have sufficient capacity.
I'm doing that.
Yes.
I'm not for a second saying I'm not doing. I'm doing that.
Yes.
Not what is my wife
Only
doing?
the school fees and the tuition fees, hostel fees.
Everything I'm doing. I'm paying off.
So if he is residing in a hostel, so that
everything is taken care of. Lord, I've annexed the documents. I'm paying hostel
that is
fees.
so. All charges with regard to the son is being borne by him.
Current now, the expenses of the college, husband is bearing. What exactly is the amount? I can take instruction. But on the last occasion, Mr.
Banerjee, he says that he will be discharging all liabilities for the son with regard to his tuition and other expenses, hostel and other things. Son is with you. Son is with you.
Son is with me.
Son is in the hostel.
No. Now he has
Well,
just now
within
joined
his
college.
custody.
With me.
So, with regard to the son, Mr. Kormokar says he is taking care of. So, how much is your requirement?
My lord, may I say
How much is your requirement?
The court came to the finding from the income tax returns that his monthly income is 4.2 lakhs. And the wife is getting 3.5 lakhs yearly from interest.
But that's not the requirement.
Let me. So this was the Lord. The court awarded a sum of 80,000 with arrears. 80,000 for the wife.
For the wife only. And son?
No.
Son, there is nothing.
Son, there is nothing. All right.
So that is under challenge.
Yes.
I have pointed out, my lord. I have filed the affidavit of assets of the husband.
Mr. Banerjee, what is your expenses? Monthly expenses, what is your expenses?
My application, I have said 5 lakhs. In my application,
Mr. Banerjee, be reasonable. Be reasonable. What is your expenses? Monthly expenses, because Mr. Kormokar says that he will discharge all his liabilities with regard to the son. Now, what is your reasonable expenses? Don't say 5 lakhs. It's
I would be submitting
Lord, kindly comes to page.
The accounts of the husband. One account out of
Mr. Banerjee,
I have shown
Mr. Banerjee,
lordship was of the view that a
yes,
person having
show me your status. How are you? What is your expenses? Reasonable expenses. Show me the breakup. What is your expenses?
Lord, kindly comes to page 76 of my revisional application.
Your revision application
Lord,
is
that is Lord CO number 2955 of 2024.
I have 3292. It's not there.
Just after, Lord.
In 3292, that's the volume now. So I have to take it.
Lord, I assist your lordship with the pages. Your lordship do not have to worry about that.
Then.
Lord, kindly come to page 73 of my application, first application.
76. That's the first affidavit.
76.
Kindly come
Yes.
to application first, Mr.
Yes, application. Show me the application.
Page
Page
73 of my application.
of your application. You are saying this, he is saying that. It is not here.
Application to the annexed process.
Yes, application, your lordship will find page 7. No, no, that is at page 73 only in their application.
In our application.
You have not annexed. That's
That
the
is not-
only document that you have made this bulky.
Not the.
But only the vital
affidavit of
document you have not
assets.
annexed.
The affidavit of assets was
Page
73.
73, my lord, the breakup is page 79. This was my lord.
House maintenance, Lord, 50,000. Fooding and other household
Sir,
for 1%.
Banerjee, clothing and personal expenses 2 lakhs. What is the material which you are using for clothing?
That is annual, my lord.
No, no.
The annual, no.
Monthly.
This is monthly.
Monthly expenses. The head is monthly.
You also could not believe that it is monthly.
Total is, my lord, 180.
Mr. Banerjee, you also could not believe that it was monthly. You are under the impression it was yearly.
Lord, cable,
Kindly come to
electricity.
the summation, my lord. Kindly come to the summation. Total is 182 he has given. So it cannot be, my lord, yearly, monthly.
No, even then, Lord, even then 182 does not arrive.
Miscellaneous expense, both
2 lakhs.
both are, my lord, yearly.
Lord, if it is
20 lakhs new car, you will purchase a new car.
There was a car, my lord, which the husband provided. That is now the certificate of fitness has expired. Cannot be used.
Mr.
Let him provide a car, my lord.
Mr.
Money
Banerjee,
cannot be given.
this cannot be your monthly expenses, a price of a car. So you will include that and you will say, yes, for every year, I will be getting a new 20 lakhs. What are you saying?
Kindly come to page 81. That is the summation. We have
Even
given those-
if it is accepted, Mr. Banerjee, it's a yearly. So you mean to say every year you will purchase a car of 20 lakhs?
20 lakh has not been, my lord.
Yes, new car 20 lakhs.
That is given. My lord, this is not added to the total summation. my lord.
The salary of a driver
What has been added to the total summation?
My lord,
Mr. Banerjee, prepare a chart, monthly expenses. What is the, please be reasonable so that otherwise sending this, you will also not be getting anything. This will go on. Again sending to the learned trial judge, again coming back. This proceeding will go on, you will also not get anything. Please be practical. So what is your expenses?
I shall come back with the exact calculation. But
Monthly expenses.
as far as an inquiry, my ground of challenge was that not the trial judge has not gone through the affidavit of asset of the husband minutely, which would have rebuilt further income. So your lordship is not
Further, Mr.
That is why-
Banerjee, you have to maintain the objectives, you have to be maintained and according to the status. Yes, so give a reasonable expenditure according to the status of the wife of Mr. Kormoka's client. So please give a calculation monthly. What is the reasonable expenses and also consider because this cannot be a rate in 2025 cannot be applied from 2014.
So both,
So
take care of both.
yes, so from that, otherwise this will go on. It's not, it can be sent again. It will go against one of you. You will again file objection. Court again challenge.
Shall come back. In the meantime,
I also want to finish it off here.
The lordship on the last occasion, I asked Mr. Kormokar whether his client will pay something. He said yes.
Yes,
he
Mr.
will.
Kormokar,
They make
pay something.
payment.
But we should pay something.
Yes, which amount you can pay?
74 is the total areas. Let him say
74
lakhs because
Lord,
some
the instructions,
Kormokar,
the
Puja is-
instructions taken by me, Lord.
Yes,
Lord, my client was ready to put in, Lord, rupees 10 lakhs upfront.
10 lakhs.
Rupees 10 lakhs
All right,
upfront.
put that.
Yes.
How soon can you pay?
Lord, may I pray for one thing? Lord, this will take some time for taking instruction, Lord, for the time.
10 lakhs you have taken instruction.
Yes, Lord, with respect to when I can pay, Lord, with time.
Sir,
Lord, let Mr. Banerjee come up with the expense. Lord, I shall also come up with the instruction. If required, Lord, the next day I shall produce
Yes,
the
something.
given instruction.
Puja is shopping is to be made. This is the expenses clothing. 2 lakhs.
for electricity.
No.
Janmashtami is over. Janmashtami is over. So puja is approaching.
I shall not take it.
Pay something within a week. 5 lakhs.
Very.
5 lakhs put in within a week.
Right.
Today we are on Thursday.
By next.
I'm keeping it.
Ready for 10 lakhs, Lord.
No, no, Lord, that
He
with
submitted just
instruction,
now.
with instruction, Lord, then in that case I will come back.
He says 10 lakhs he will be putting in. That will be prior to puja. So do something within a week.
And
Thereafter,
at the same time, your lordship, yes, he comes back.
and
with
Mr.
calculation, we'll finish it.
Kormokar, you please enhance the amount of 10 lakhs for the time being, because dues as per the rate is what Mr. Banerjee has said, 75. Even if your average is made 35, a conservative
Lord, I have given
estimate
a chart to your
cannot be
lordship.
less than 25.
Lord, I have given a chart to your lordship indicating
Conservative,
1/3 and 1/5.
Mr. Kormokar, conservative estimate cannot be less than 25.
Huh.
Cannot
Yes,
be less
yes,
than
yes,
25.
yes.
So that is why,
That is
so 5 you pay and you increase that amount, pay something to make
Lord,
it up to
once and
20.
for all, your lordship finishes of this matter here.
That is if you, both of you, Mr. Banerjee, do one thing. You make a calculation, give it to, share it with Mr. Kormokar so that he can also come with instructions with regard to that. If both of you can arrive at a consensus with regard to, don't say that his account, these are the credits, those are the credits. So if you look into that, it will never end. Be reasonable.
So far as not the monthly payment is concerned, not really not. He's paying. He was paying 30,000 for 2 months.
That note I shall be. Let him agree to a reasonable amount.
How much he is paying?
30,000 he is paying. Court has fixed at
80,000. I am not saying anything. He will pay only 5 lakhs. The amount which he is paying, that he will pay.
For 2 months. For last 2 months, he's not.
Mr. Kormokar, you have not paid for the last 2 months.
Lord, I had taken instructions, Lord, in August also he has paid. Yes, in August also.
Mr. Kormokar,
July,
please,
August paid.
Mr. Banerjee is saying that you have not paid. So if you have not paid, I'm not passing any orders on that. Pay that amount which you are paying.
Very.
Over and above this 5 lakhs.
Yes.
The learned, Mr. Banerjee, learned next matter. This is 1263 and 64 both. Yes.
Item number 380.
Yes.
I'm the petitioner, my lord.
Yes.
My lord, the suit for partition was filed.
This is expeditious hearing.
Yes, my lord.
Yes. What is the stage of the suit?
It's for final hearing.
Final hearing means evidence is going on.
No, my lord, preliminary decree for the partition was already passed by learned court below on 2017, in 2017. 2007.
Final degree proceedings is pending.
Yes.
When the preliminary decree was passed?
12/12/2007.
12th May 2007.
Subsequently, my lord, I have made an application for appointment of partition commissioner.
That has been made.
That has been made.
Commission held. Commissioner submitted a report.
15 years.
Now it's for acceptance of the commissioner's report. What is the next date fixed?
Next date was day before yesterday, 19th of August.
What is the next date?
Next date, the petitioner, the person concerned has not informed.
This application under article, this application. Yes.
Lord, expedite disposal of the suit, my lord. Suit for partition of 2019. Now, my lord, next date is fixed on 12th September for hearing of temporary injunction petition, my lord.
Temporary injunction?
Yes, my lord. 2019 suit. Lordship kindly see, my lord, I have annexed for a seat. Suit for partition, my lord.
This application under article 220.
Well, I am for the petitioner.
Yes.
When this is a suit for declaration and injunction, like I am the defendant there. I file an application for Order 7 Rule 11 CPC. Order 7 Rule 11 CPC. I paid to expedite dispose of the application. They were filed on 18/11/23 and not been disposed as yet.
What is the next date fixed?
Next date fixed is valid today itself.
Today?
Today itself because
taken adjournment there.
Huh?
You have taken adjournment there.
No, but that is for extension of injunction order, not this.
21st
of August
2025.
Yes, today.
This application under Article 227 of the Constitution of India. Yes.
I appear for the petitioner, my lord.
Yes.
The petitioner is a defendant in the code below, my lord, suit for eviction, my lord.
Affidavit of service?
Yes, my lord. Earlier occasion, the coordinate bench directed to serve, my lord, has served. I have also given a notice for mentioning also to the.
Who is appearing?
Kaushik Dash. I have given through email also. I didn't have a suit for eviction, my lord, in which my lord 7172 was disposed of, thereby holding me defaulter for 1 month. Although my lord,
1 month.
1 month. Although my lord, I have deposited the rent receipt within time before the court, but the duplicate was not with me, but original was lying with the record. Thereafter, I filed an application for 151, saying that the original was there, but court rejected that 151, challenging which have come up before your lordship, my lord. Now, kindly comes to page 39 once, that is first order, order number 61.
First order under?
That is 17172. They're holding me defaulter for one month, my lord. Month of January.
Rent is 166.32 paisa.
That was my lord.
Rounded off to 166.
Kindly comes to page 38, that is the challan.
Shortfall 165.
Kindly 165.
Yes.
Kindly sees my page 39. Petitioner is directed continue paying 165 within 15 of every succeeding month. 165. Page 39.
Why? Your rent is 166. Why you will pay one?
But that was my lord.
No. This 1 month.
Yes.
Your rent is 165.
Yes.
But with interest, it's 166. So this amount was paid within time.
Yes. I paid within time. But since the duplicate copy was lying with the clerk of the lawyer, that was not produced. But the original was with record itself.
Now, after this order was passed, what did you do? You filed 151 application.
Yes.
Where is that?
Well, the kindly comes to page 40.
Page 40, yes.
Page 41, I have, third paragraph, I have specified, my lord.
Where have you said that it's lying in the records?
But kindly see, but it's a usual practice, my lord. Once we deposit the civil deposit, the original
Have you
goes.
stated that it is lying in the records?
But we generally have the duplicate copy. The original is always with the record, my lord.
You have not stated that in the application itself.
Original is always with the record, my lord.
Should have stated
that was not there, my lord. But we have filed within time. Because the application was disposed in February.
1 month is of January. Where is that?
Kindly page 38.
January. Affidavit of service filed in court today is taken on record.
Yes, my lord, I am for the petitioner.
Yes.
I am for the dependent petitioner, my lord. Suit
Yes.
for declaration and permanent injunction, my lord.
Yes.
Only prayer for speedy disposal of the court below, my lord.
Speedy disposal of what?
My lord, page 4, my lord. Written statement was filed by the dependent petitioner, but since August 2018, no progress of the suit.
What is the suit for?
Suit for declaration and permanent injunction.
This
I am for
application
the
under
dependent, my
Article
lord.
227.
The suit for eviction suit, ground for building the building. The plan will be expired shortly. The 7172 pending since 2023.
Expeditious hearing.
Expeditious
hearing.
For 7172 the petition file.
Is the next date fixed?
Well, next date fixed on 15th September 2025.
15th September 25.
25.
7172.
7172.
This application under Article 227 of the next.
For 816.
Lordship, I am appearing for the petitioner.
Yes.
Lordship, 3 suits are pending before the same court and between the same parties relating to same property. And that's why the petitioner has made an application under 151 in TS number 800/2015, where the application was numbered as miss case number 23.
What happened to that application?
My lord, that has not been heard yet.
Oh, expeditious hearing.
Expeditious hearing.
Of the application under section 151, which order records that?
Lordship.
By which order? That is pending. What is the next date fixed for?
Next date, my lord, this application has been filed in 19th July.
You have filed that application in which suit?
I have not.
You have filed that application in which suit?
3 separate applications filed in 3 suits.
One civil division application cannot be maintained. In which suit this application?
My lord, this application in connection with TS number 800.
800 of 2015.
800 of 2015.
But you have not annexed that order sheet. 800 of 2015.
800 2015.
You have annexed the order sheet of Title suit number 134 of
134
2016.
In relating to TS 134 also, the petitioner filed the same application, that is in page.
This application under Article 227 of the yes. Yes.
Order to Rule 6, my lord.
Yes. Rejected rightly.
Only allow me to proceed your lordship whether it is yes. Why, today, around.
Mukherjee, it is to be allowed or rejected?
Whatever he will say.
Yes.
The suit for declaration. My learned friends, client filed a suit for declaration. This is a tenant. Malkai takes up the plaint itself in the earlier suit. Can you turn to page 42?
No, give me the background. What happened? What is the suit for?
Their suit for declaration and injunction. Initially, it is for declaration of tenancy right and injunction.
Their suit.
Their suit.
Your suit for eviction.
Eviction.
106.
According to them, in their suit, they have pleaded this is the amount which they used to pay month-wise. Subsequent suit, they have categorically admitted that yes, we have received the notice. The amount which I have mentioned in the earlier suit is more than 10,000. And notice was admitted. And they replied.
Decree has to follow.
Decree has to follow. Now, my fault.
106 you are saying.
106 in that sense, because they have admitted. No, in their register, they said the rate is 4,000 such and such. Service charge is different and electricity charges are different.
But rent is below.
Rent is below. Now that came up for consideration. I'll satisfy your lordship. It takes up page 42.
Everything will be composite rent.
Page 42, my lord. This follows from the earlier occasion also. And turn to page 42. Page 42.
Order 12, Rule 6 has been given an expanded meaning.
Yes. Or otherwise. Mercalli consider Order 12, Rule 6 not limited to, but otherwise. That is why, my lord.
So, otherwise expanded to.
Any pleadings which is admitted, I cannot say that it is unequivocal admission to that effect. But it's fundamental lordship the earlier occasion, unequivocal admission regarding any facts which does not require any investigation.
Page
42.
42 is what? Is the plaint?
They are plaint.
They are plain.
Yes, that's from
And you want order 12 rule 6 in your suit.
they have
That is the eviction suit. All right.
both the suits are hard analogous.
Honestly. Yes.
I am drawing lordship attention. Can you turn to page 49 once? That's why বলে যাচ্ছি কিন্তু তুই যেটা বলছিস। Can you turn to page 48, paragraph 9? যন্ত্র ছাত্র যন্ত্র।
Yes.
That the plaintiff submits 8 numbers of employees staffs are being engaged in the plaintiff's business, not only for the plaintiff, but also for the persons and their family members are totally dependent upon the said business. It is their only livelihood and some source of income. Apart from the said business, they have no notice, though no other separate and or alternative source of income, and even also on several occasions the plaintiff is requested to settle up to the dispute, but the defendants, especially the defendant number 2, turned deaf ear to the said. This was to the interest to get upset about a monthly rent from the plaintiff. It is pertinent to mention here, apart from the monthly rental of rupees 4,000, the plaintiff also paying maintenance charges rupees 5,000 and electric charges on about 10,000 per month. Naturally, such abnormal illegal demand of enhancement of rent does not acceptable on the part of the plaintiff, as a result of which, though the monthly rent maintenance charges was accepted by the defendants, but despite a repeated request and reminder as made in the part of the plaintiff, the defendants for the month together did not issue any rent receipt in favor of the plaintiff, ultimately which compelled the plaintiff to pay the monthly rent through the money order from the defendant number 1 to June onwards. টাকাটা ইয়ে রেখেছিল হ্যাঁ না 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 ওইখানে বললো না টাকাটা ইয়েতে দিত।
What is your written statement against this?
Yes. Can you turn to page 61? Yes. If your lordship, I'm skipping over the, can you turn to page 65? Last 5 lines. Payable of the good trust and believe the defendant plaintiff never asks for issuance and insists in favor of the plaintiff concern, favor of the body
Yes,
business.
65, which portion, Mr.
Last 5 lines from the bottom, it is the continuity of the single paragraph, but the relevant portion which is followed by lordship, what is the actual rate which I have stated. October 20 is some difference of dispute with last line, my lord, the plaintiff and the defendants are cropped up on or that since the time of defendant number 2 authorized agent of the defendant number 1 has.
No, Mr. I cannot find it out.
Internal page 5 of the
Yes.
statement. Last 2 lines from the bottom.
Last 2 lines. Or that since October 2015.
Yes.
Yes.
The difference and dispute.
So this is the denial.
This is a denial. No,
That
no,
is your
after that.
positive case.
After that, ballot can you consider, that is why I am reading. That is the entire paragraph. Ballot defendant authorized to was started to demand huge rent of rupees 20,000 per month from the plaintiff concerned, which has not been accepted. My lord is asking my positive case.
Yes.
No. Equity. Joseph. Your lordship, this is the only paragraph. It is entirety. Page 67, my lord.
Only one thing.
Rupees 20,000.
This paragraph 9.
Yes.
How have you dealt with paragraph 9?
Paragraph 14.
Page
60. It starts on page 64. There is a continuity of the
64.
Yes. This now
Everything you have denied.
Yes, no. That it is there that the defense cropped up.
Yes. Everything you have denied.
যেখানে টাকাটা ইয়ে করতো খাতায় লিখতো অ্যালিগেশনটা ইয়েটা অ্যামেন্ডমেন্টটা
Yes, show me your plaint in this eviction suit.
For that, Malad, can you turn to page 45 once? I missed out, Malad.
Page 45.
paragraph 5.
Yes.
That no such agreement was ever made by and between the parties. Even the defendants, page 45. Paragraph.
Yes, yes.
What? Never issued any resolution in favor of the plaintiffs. Thereof, the electric charges, monthly rent, as well as the maintenance charges was duly received by the defendants. Number 2, on which the defendant number putting his handwriting at the over a hand note which is lying under the custody of the plaintiff. Apropos to this, my lord, can you turn to page 73?
Yes.
This is the documents relied upon by the plaintiff. First is the hand notebook. It is their document.
Yes.
Next page, your lordship will find 75.
Yes. Yes. Show me your plaint.
Yes.
In this suit.
58,167. So this is the hand, my lord. Now, my lord, can you consider my page 31.
Page
31.
31 is your plaint.
Yes. 157 টা একই মনে হয় রিপিট হয়ে আছে মানে দেখতে দেখে না রিপিট আছে
Yes.
If your lordship kindly consider, my positive statement is that the defendant was inducted as a licensed in respect of the suit property running a restaurant under the same style of Marwa as license is 25,000 per month payable according to the English calendar month. License has been created. Kindly turn to next paragraph 4. The defendant did not pay license fee on and from the month of February 2015, and an amount of rupees 4,75,000 is found due and payable by the defendant in favor of the plaintiff. Be that is may, the plaintiff through his authorized agent, the advocate such and such, issued a notice asking the defendant to quit, vacate, delivered up the peaceful vacant position of the schedule mentioned property with the expiry of the month of June 2015, and defendant will receive the said notice but failed to neglect to make over the position. Hence this suit. The defendant issued a reply letter through such and such on false and flimsy pretext. Now, my lord, can you consider how this paragraph number 3 and 4 has been dealt with?
Yes.
Now, my lord, kindly consider how this paragraph, 2 paragraphs have been dealt with by the defendant.
Yes.
That your lordship mind, page 39. It's though it starts from page 37. I'm drawing your lordship attention.
Yes. Which paragraph deals with that?
Yes. That is paragraph number 13, 12 and 13. সেটা হলো
Yes.
So therefore, 2 aspects my lord has to consider. What is the rate? Their document shows it is 19,000 per month. Page 75 once. That is why my lord can turn to it is their document they have relied upon. is a fixed amount 90,500. April, August, September, October 58,500. November, December, January 58,500. So it is more than 10,000. They admitted the receipt of notice. If it does not come within the purview of rate control legislation and a fixed amount of money is deposited, paid.
Mr. Rai, what is the object of Order 12 Rule 6?
Can you consider Order 12 Rule 6?
Is it not related to the scope of the suit, or it's anything? The horse extraneous to the scope of the suit, any fact admitted, decree will be passed.
That is why, my lord,
I'm asking you.
This is a suit for eviction.
Mr. Rai, a plaintiff files a suit on certain grounds, claims a relief. Now, if the defendant disputes those, then it gives rise to an issue. Material proposition of fact or law asserted by one, disputed by the other, gives rise to an issue. If that is not disputed, then it's an admission. So it has to relate to the suit.
Yes.
So now the question is, what is the frame of your suit? What are the pleadings in your suit? What is the relief claim? Whether on the basis of the pleadings of your suit, what facts have been admitted? Whether the case which you have made is admitted either in their pleadings or otherwise anything. So it has to be that your case in the plain has to be admitted.
Yes.
Not anything. He makes another suit. He gives a written statement. Those two are to be.
That is why. What are the issues? First is the rate of rent. This is the dispute.
Your suit is a suit for eviction of a license.
Licensee.
Your suit, the scope of your suit is eviction of a license.
Licensee. That this is the license fees.
Show me admission that he is a license. He is a licensee. Show me that admission.
That is why I have said that I am inducted a licensee. He said he is a tenant. He used to pay rent which has been admitted more than rupees 10,000. Why not can you consider that? They filed their defense is that the document which they have relied upon, that has been relied upon by us. It is not the I am disputing the document. It is their document which those are relied upon. And the notice of eviction has.
Mr. Rai, what decree you want the court to be passed?
Eviction, main profit and other things will be kept aside. Mean profit and other things will be continued.
Eviction under what provision?
Under the Transfer of Property Act.
Show me under which provision you want this eviction. Transfer of Property Act. Transfer of Property Act. Yes. You have disclosed the notice which you have stopped here.
Yes.
Show me the notice which you have disclosed in your suit.
That you'll also find at page. Page 27.
27 or 20 or 27? Yes.
Their reply is 29. Mine is 27.
This is the basis of your suit.
Yes.
So you have to get a decree under section 106 on the basis of this notice.
This is my claim.
Yes.
Now kindly under next reply. What is the reply? Last paragraph.
Yes.
By denying and disputing, last 3 lines.
Page
Sir,
30.
Page 29.
Page 29. Yes.
By denying and disputing such amendment as made in your letter under reply, my client has already filed a suit for declaration of an injunction, which is number 7/20/2016, as pending for the learned civil judge Howrah for disposal. In view of the above facts and circumstances, I being the legal authorized agent, my above named client do hereby request you to withdraw the aforesaid notice, which is nothing but a misconceived and untrue statement on the basis of such false instruction, part of the client. Your client chooses to proceed further in this regard, to have referred notice, then it will be on risk and peril. Therefore, my lord, only one thing only. So my note, his defense is on the basis that the suit has been filed for the purpose of establishing his character or right over the property in question. এটা কই এটা একটা সুমেনশন আর ইয়ে জাজমেন্ট বার করছিলাম না আমি সেটা ওটা
Yes. Yes.
So therefore, my lord, 2 things. There is privity of contract, admitted. He has filed a suit for declaration.
Privity of contract, you say license and licensee.
Licensee.
They say landlord tenant.
Landlord.
No admission, Mr. Rai.
Read. That is why, precisely that is the paragraph 4. My lord has to give little daughter.
Are you treating them to be a tenant, Mr. Rai?
No.
Please make yourself.
I am not admitting them as a tenant. My case is the licensee. And license fee is rupees.
That is what. If your case is that of a licensor and licensee, your case is that is a suit for eviction upon revocation of license, you have to show that that case has been admitted by them, pleading or otherwise anywhere. So their case is simpliciter of tenancy.
Rent of rupees 29,000.
In your suit, you will take advantage of their pleading, this written statement and say, yes, though I have filed a suit for eviction of a licensee, you have said it's so we are tenants. So 106, that difficult to digest, Mr. Rai.
Subject
Very difficult to digest.
So far the suit for eviction of a licensee, what I have to prove?
Yes, show me, the decision you want to rely upon, division bench. Show me. Yes. Yes, please. What was the suit for here?
Suit for eviction of a license.
Under?
That is 106.
106. Show me that paragraph. Show me the facts that it was a suit.
Second paragraph has been preferred by the defendant in
paragraph
2. Paragraph 2.
Yes.
The 2 appeals my lord will find.
Yes. For eviction on the ground of
eviction on the grounds of notice under section 106
and area rates.
And area rates.
Yes.
Here also I have issued the notice. Licensee, license are governed. You have to consider whether a suit for eviction of a license is governed under 106 or any other law in force. He has to prove under what capacity he is residing. He said, I am a tenant. Very well. Under the tenant, licensee, licensor, lessee. Whatever be the term used under section 106. If you want to come within the purview of the Red Court legislation or General Act, this is the 2 things I have to your lordship has to consider. On his own documents and admission made.
Yes, which paragraph you are trying to rely upon?
If your lordship can return to only 8 onwards.
Yes.
7. In view of the service of such notices such as such, it is argued that the plaintiff waived the earlier notice dated such if there any admission of the defendant regarding service of notice dated 22nd September 2018, the same would be relevant for the purpose of grant of eviction decree. On the other hand, since the no averment in the application under 12 Rule 6 of the Code, the effect that the defendant ever admitted the receipt notice that such as the learned judge acted illegally, relying on the purported admission to grant judgment on admission thereby traveling beyond the averments made on the plaintiffs in 12(6) application thereof. The account of the defendant contended, although Order 12 Rule 6 of the Code investigates grant of a judgment on admission either suo motu or an application, since the present impugned degree has been passed specifically on the application filed by the plaintiff, learned judge ought to have confined himself to the application and not travels beyond the same. Learned judge appearing the plaintiff, on the other hand, says violation such and such for the provision in a suit for recovery of possession from a tenant whose tenancy is not protected under the provision of Rent Control Act. All that is required to be established by the plaintiff landlord is the existence of dual relationship of landlord and tenant between the parties and the termination of tenancy either by lapse of time or by notice served by the landlord under 106 of the Terms of Property Act. So long these two aspects are not disputed, the court can pass a degree in terms of Order 12 of the Code of Civil Procedure. So
you are on paragraph 10.
So there, if you logically consider what otherwise this is the suit. In their reply, they have categorically stated that whatever the reply, they have filed a suit for declaration of the tenancy right. The tenancy right based on the fact that yes, monthly this is the amount I used to pay. If this is the admission on their part, it comes. It does not come within the part.
So in a suit for eviction of a licensee, a decree under the Transfer of Property Act 106 will be passed.
I have to prove my title. Whether the better title can pass grant a degree or not. Even if Malakali consider, I filed a suit against the license, I am unable to prove the license. Then Malakali, what on the ground of better title, I am not entitled to grant a degree.
On the ground of better title.
Yes, they have admitted ownership never challenged. They said, I am a tenant, this is the amount of rent. I said, you are my licensee. So, ownership not disputed, the status is disputed. The status they had to prove. I have said you are licensee. Whether they are tenant or licensee or lessee. Lease is not, because it is not a registered document, more than 11 months. So what will be covered? Then, under the Terms of Property Act, month to month license. Month to month.
Month to month, thereafter.
Tenant or licensee, whatever, lesser, lessee, whatever bilaterally considered.
What, whatever, be specific, Mr. Rai. Don't say.
Lessee. Then one a lesser, what it means?
Admitting him to be a lessee.
Lessee, tenant, whatever.
You are admitting him to be a lessee.
Anything bilaterally considered in that way. But what will be the status of the property in question? Whether he is under.
He cannot become the owner.
He cannot become the owner.
So you have a better title, you are entitled to a decree.
Yes, he said that I am a tenant, I am protected under the Rent Control Legislation. It is his case. I have to prove that yes, the amount you have paid, you are not entitled to get any protection under the Rent Control Legislation. Then you come with the purview of General Act. The General Act says that you have to issue a notice and you have to prove there is a dual relationship. The dual relationship did not deny it. As soon as the notice is received by lot, then what will be the effect? If bilaterally considered in that way also. If somebody was inducted as a licensee and unable to prove that induction is not, but on the ground he has a better title, what should I put this question to myself? What suit he has to file? Under the Transfer of Property Act or the Specific Act? My declaration is not required, subject to question, my lord. So the ground of better title I am entitled to. So as on this day, their defense based on the fact that I have filed a suit on basis of which my status is subject matter adjudication, so you cannot issue the notice. From their documents, if I satisfy in the court, on the pleadings made by them, itself it appears the documents relied upon that does not come in the purview of the.
Sir, on the ground of better title, it can be under Order 12 Rule 6 on this.
Licensee.
I'm asking you, if according to you, you are entitled to a decree on the ground of better title. So can it be? No, that is why. If this fails on the ground of better title, you are entitled to. But I'm asking you, can it be under Order 12 Rule 6 on the basis of these pleadings?
Now, one can consider the tenancy person claiming tenant under the landlord. If he is not entitled to get protection under the rent control legislation, what will be the status of that person under the Transfer Property Act?
You can, Mr. Rai, I'm not disputing. I'm asking you, my question to you, whether on the basis of this Order 12 Rule 6, on the ground of better title, a decree can be passed right now.
I have to prove dual relationship. That is precisely what the division will say.
Dual relationship, Mr. Rai, is another thing.
Yes.
It's a Transfer of Property Act, licensor, the lessor-lessee relationship. There is a procedure for determination of lease under Section 111. 111H says 106. So these are the things in which that's one thing. Other thing you said that in a suit for eviction of a licensee, even if licensor-licensee relationship is not approved, even then you are entitled to a decree on the ground of better title. No dispute on that proposition. But I am asking you, my question to you is whether such a decree on the ground of better title can be passed under Order 12 Rule 6 on the basis of documents available on record. That's my question to you. Please satisfy me on that.
Now, can you logically consider paragraph 6 of this judgment itself?
Yes.
The defendant places reliance on Section 113 of the Transfer Property Act on such count and argues that in terms
paragraph 6
yes.
starting.
No. It is
paragraph 6 of
it starts from the first page.
It is contended.
Yes, that is why.
Yes. No, which portion you are placing?
Next page.
Yes, next page.
The reliance. What is fundamental?
Defendant places reliance upon. Yes.
What is fundamental lordship? The lease and license.
Yes.
The expression implied consent of the person who is to be given by an act on the part of the person giving is showing an intention to treat the lessee lease as subsisting. What is fundamental? 111, 13 will come. 111, 13 is holding over.
No, I'm not on holding over. I am saying in order to file a determination of a lease, the modes have been specified under 111.
Yes.
111H is also one of the mode by which it can be determined by issuing a notice under Section 106. So I'm on that. I'm not saying holding over. Holding over is a different concept altogether. So I'm not on holding over. So I'm saying, so this is 106. So that's lessee relationship has to be determined. You are entitled to. So there are several types of suits you can file, expiry of lease, other things also. My question to you is, you have filed a suit for eviction of a license. Maybe even if you fail to prove this licensor-licensee relationship, you can get a decree on the ground of better title. No dispute on that. My query to you is whether under Order 12 Rule 6, on the basis of the pleadings available on record or otherwise, Order 12 Rule 6, such a decree can be passed on the ground of better title.
My lord is considering the Order 12 Rule 6 on the basis that the unequivocal admission to the statement pleadings made or the relief claimed.
Or otherwise, I am on or otherwise. Mr. Rai, admissions have to be
unequivocal.
Yes, but
that
has to be within the scope of the suit. Cannot be extraneous to the scope of the suit.
That is why Royal Lodge is the reply to the notice.
Rai, why Order 12 Rule 6?
That is
because facts which are admitted, for that a trial is not necessary. For that, yes, right now judgment on admission can be passed. Other issues has to be decided. That's the object of Order 12.
That is why precisely. That is why.
So it has to be within the scope of the suit, not extraneous to that. You will make a suit. He will take another defense. You will say yes. Now my notice you have accepted. You have said that rule rent. So it's not under the rent control legislation. TP Act, notice issued, decree. Very difficult to digest, Mr. Rai.
It is not degree. If you're logically, somebody's defense is based on some pleadings, whether I can use that pleadings as an admission against him or not.
That is why I started.
That is
admission of what?
Rent.
Admission of your
rent.
No, admission of your case.
That is the rent.
Has to be admission of your case.
That is why I have to prove that yes, he is admitting this is the rent. After that, whether my lord, under what statute one I put this to myself, he should be termed to be a tenant under the rent control legislation. If I said that yes, rent is rupees more than 10,000, then whether I am entitled to get a declaration or any admission, any proof is required that he is not entitled to get protection under the rent control legislation.
Yes.
It is their case, their documents, and they have said that my status is based subject matter of dispute which is pending.
So your simple case is that according to their own admission, they have admitted that they are the tenant. Rent is cumulative, exceeding 10,000, takes it out of the rent control legislation. It's a suit, basically, they have admitted. So the notice, service of notice, 106, so decree is to be followed.
This is
anything, any decision you, any other decision you want?
No, my lord, so for this, actually, yes. This is the only judgment I am relying upon, my lord.
Any other judgment or otherwise anything you want to?
The recent Supreme Court judgment, there is some expansion of Order 12 Rule 6, 2025.
What is the effect? You
What
can
is the
also
unequivocal admission, to what extent it can be down to an impact of the
necessary implication of those pleadings.
There must be an admission. Admission. There must be an admission.
There must be
An admission.
yes, yes. Admission from the statements also not directly, impliedly, because from this it can be meant this. If you want to cite those decisions, you can cite that.
Kindly see page.
Kindly see page 44. Okay?
Page 44. Oh,
page 44.
Page 44.
Yes.
But kindly see, my lord, paragraph 4. So that
Yes.
initially the monthly rent was rupees 2,000.
Yes.
2,000. Subsequently, it has been enhanced, and the present monthly rent of rupees 4,000 per month.
Yes.
Apart from the monthly rent, the plaintiff used to pay electricity charges, which is standing in the name of the relation of the defendant, and also paying other maintenance charges to the defendants. Now, my lord, kindly skip over up to page 49.
Paragraph 5.
ওটা যদি দেখিয়েছিস page 49, my lord, from the top, my lord, that I say, my lord, rent was initially 2,000, subsequently it has been enhanced to 4,000.
Now it's 4,000, 5,000 and 10,000.
No, in
19,000.
No, my lord. 4,000, then other electric 5,000.
Electricity charges, Mr. Mukherjee, it's a fixed amount. If it's a fixed amount, it's part of rent. Maintenance fixed amount is part of rent. Cumulative is excess.
I'm not on that. Now, my lord,
You are not on that.
Now, my lord, that is obviously, my lord, from 2002. Now, my lord, what is my
suit? 2000 now. The suit is now.
Present, at
So
present.
at present, it
Now,
takes out of the rent control legislation.
Now, my lord, what is my suit? My suit from the beginning is that, but I'm the tenant. If you lordship see my pleadings, now, my lord, in the four corner of the my plain written statement, or rather his plain my written statement, your lordship will not find any admission that I admitted that his case is that I am a licensee, lease expert, therefore has to be evicted. My case is rent. Now, my lord, what he is showing, that everywhere I have denied. The court below rejected on the ground, there is no specific admission, it has to be decided. Therefore, my lord, if your lordship see
No, Mr. Mukherjee, all are admissions. His notice served, you have admitted.
That I'm saying.
Rent is admitted. What is
No, rent is not.
More is necessary
Rent,
in a suit under section 106.
Rent is not admitted. If your lordship see once minute.
What rent is not admitted? 90,000 you have said.
That has to be. That has to be. If your lordship see the documents.
Mr. Mukherjee, there are two things. If you are out of the rent control legislation by virtue of this, so only 106 notice service is necessary. So because there is no registered lease deed, according to you, there is no registered lease deed.
What is his suit for? If your lordship consider his plaint.
Yes. What are you looking for? Anyone will come.
Poor tenant, like my poor Jun.
Yes.
Now, kindly visualize his suit. What is his suit? His suit is
for eviction of a license.
And my lord, your lordship is kindly see my written statement. Or rather, my lord, if I permit to show, but his written statement, page 62. But I will show, my lord, from first, my lord, page 11.
He has not said anything. He has only denied your case.
No, if you are 60 once more, page 62, paragraph 11.
Yes.
Paragraph 11, second paragraph. The plaintiff was inducted as licensee.
Yes.
Licensee in respect of the suit property for running a restaurant under the name and style Marwar at a license fee to 25,000 per month payable according to English calendar month. Although licensee has been created, no formal document of license of or receipt wherever it is his case also by the defendant in favor of the plaintiff. It is pertinent to mention here that before inducting the plaintiff as a licensee, the defendant previously inducted Manoj Kejriwal as license fee. This I am just skipping over.
No, where is your admission with regard to service of notice? Mr. Rai, where is that admission?
Notice, but kindly see once.
Where is paragraph 10 of his plaint?
No,
My claim and the WS.
Where has he admitted?
Yes. My
It has to be in his written statement.
written statement, Bharat.
Where is it?
My
In your suit.
Page 39, if your lordship can.
Page 39.
Yes.
Written statement.
Paragraph 13.
Suit number টা
No,
বল।
paragraph 13. No, it
That
has
is
been
reference-
denied.
No, after that.
Is valid or subsisting?
With reference
And
to
third upon the defendant is valid and binding upon him in any manner whatsoever.
start. With reference to the statements, paragraph 4, it is categorically denied.
Yes, after that.
After that. Denied. That the
The defendant did not pay alleged license
Not
fees.
as alleged, or so this is also denial, or that the lawyer said notice are sent and served upon is valid
Is valid.
and binding upon
On
him.
him in any manner whatsoever.
Denying.
There is no denial regarding the service. The notice is bad.
Valid and binding.
My lord is so denial regarding the quantum, notice is not valid.
Yes, Mr. Mukherjee.
No, if you actually consider once my written
The English as I write it.
What?
This is the English as I write it.
and that is your lordship, everything we used to write does not admit correctness, say what appears from the record. But here, my lord, everything has
No,
been.
no, no. There is
Finally-
something here.
I can't improve this, but my lord, considering the aspect, but what the scope is order 12 rule 6 is that, my lord, whether there is a specific admission.
Any decision, he has cited a division bench
A
judgment.
division bench judgment, if you actually consider once, my lord, paragraph, but 13, my lord.
Yes.
Paragraph 13 and 18, but this case is completely different. Kindly consider paragraph 13 and, my lord, paragraph 18. I filed a suit earlier. This judgment, my lord, my respective submission is not applicable in my case. Considering,
Any other thing?
I'm not. Because, my lord, the learned trial just said, my lord,
Mr. Rai, anything in reply?
Only
Want
the
to cite,
scope.
you want to cite those decisions?
If one lord wants one,
No, yes. It's
then
yes.
one lord, tomorrow morning, one lord, not to attend.
not to attend.
করো।
একটা লয়ারকে মেরে মাথা ফাতা ফাটিয়ে দিয়ে
মেরে ফাটাবো। Justice is
Kemen Rai's sons, my lord.
Justice Kemen Rai's son. My lord,
fix the other matter yesterday at 4 p.m. Lordship could not take 356.
Which
That
item?
matter, ma'am. 356 one.
356.
Yes. Yesterday it was fixed at 4 p.m. Obviously, my Lordship couldn't take it up, and under great difficulty, I could fix up the matter yesterday.
Yesterday you have taken time.
No, I am not taking time.
Yes, yesterday time was taken. She was there.
Time ki nahi hai.
You are there. She prayed for time on your behalf.
সাড়ে চারটের পরে after 4:30
My
my
lord, he is not there.
Lordship goes on. Our poor lawyers, we have to do some arbitrations also at 4:30. Lordship knows.
Was called on.
No, 4:30
Adjournment was taken.
4:30 I never.
I sat up to 5:10. I was here up to 5:10.
I know. But my Lordship understands we have to, my lord, কুড়িয়ে বাড়ি।
Say that because live streaming is on now.
My lordship.
Live streaming is on.
Truth is the truth. My lord, kindly.
Clients will fly away if they hear this
My lord, kindly give
from you.
Then my lord, kindly give one date, my lord, because this is that bank matter. Lordship has heard both of us. There is little bit.
One second.
Very really submission is required. Lordship asks a clarification from. Lordship will remember, my lord.
How much time, Mr. Banerjee? The only difficulty is
Third of
before the
September.
vacations, it is very difficult.
They have made the publication also during pendency. Lordship has recorded that. Before 3rd September.
আচ্ছা কালকে কি আছে? কালকে আছে you will take.
I will only take 10 minutes more. 10 minutes.
I will 10 to 15 minutes. Lord, I will cite 2-3 judgments and some documents.
কবে
15 minutes.
সেপ্টেম্বরে যাবেন না? অগাস্টে দেখুন কি আছে, সেপ্টেম্বরে আর কি লাভ হবে।
সেলটা কবে? 3rd
September.
1st September টা কি? 1st September.
26
26th I am busy.
Banerjee, please make it.
I'm not
Otherwise
there.
it's difficult.
I'm not there. Otherwise I would have done it. I'm not there. September. 3rd September বলছো, একবার বলো ঠিক করে। 3rd September বলছো সেল। হ্যাঁ। 3rd September না 8th September?
3rd September.
3rd September is the sale.
26th you are not here.
I'm not there.
Virtual, physical.
From Cuttack High Court, it is little difficult.
Why?
But if the matter does not end, my lord, kindly keeps it on, my lord. First.
Every day matters are being fixed. That's the difficulty.
22nd after great difficulty, one Mr. Mitro got and I got, my lord.
29th and 20.
What time?
After the division bench, there is a division bench fixed at 3, 3 সময়. After that, any time after that you can continue.
Kindly, my lord. That is very risky, my lord. Any time after that is very risky. It would be dependent on that. Is that division bench which lordship sits with Justice Banerjee? The other one. That is very risky.
That will not take much time.
Or
You
any
can have
other-
your
any-
time.
Any other day. My lord.
That's the difficult, Mr. Banerjee. Every day matters are fixed.
1st September.
First আছে.
1st September.
1st September is monthly list.
Or my lord.
That is why that date is
25th.
free.
25th.
25th.
Monday.
Monday also you are saying nothing will happen.
I don't think 2 days. Would be tomorrow. 25th.
Monday is fixed. And once, if tomorrow and Monday, if you take some resolution, then it's difficult. Everything will go. That's the difficulty. Mr. Banerjee, 4 p.m. fixed matters are there. Prior to that, it's difficult because the motions are there. I do not have any difficulty, Mr. Banerjee. It's only
Keeping it on 29th.
29th I can keep it.
At what time, my lord?
12.
12. After 3:30.
Because I won't be doing, I have to do it on virtual mode, but I have a matter fixed from 2:30, Malad. So
2:30, how long it will continue?
she keeps the matter only for me since I go there, Malad, to Delhi High Court.
How much time?
Till 4:30.
Till 4:30? Then it's difficult on that date.
আমি ছেড়ে দিচ্ছি, অন্য
অন্য কোনো দিন একটা দিন আছে? Friday and Monday it's not there, then everything will be.
Depends on the come and apologize. It's all right.
No. So no, let us. If that is okay, it's okay. Otherwise, then everything.
Tomorrow nothing is tomorrow is lordship can take it tomorrow. It's closed. কালকে it's closed.
যে ক্ষমা চাইতে চাইতে কালকে
No, tomorrow.
Book it up. 260. I will pick it up now. I'm ready with the matters. I'm for the father. So 3 p.m. on 4 p.m. হবে.
Daily 3 p.m. please.
Lordship, may I?
Matters pending. See, let me call on those.
Would you like to fix this on Tuesday then? Since Friday, Monday, there's a difficulty. Tuesday,
call the next matter.
Dekhe dao chot kore.
Item number 358.
My lordship, may I mention a thing, my lordship?
All which to mamla.
Item number?
Lordship.
Monthly listed gulo?
Malad, I have concluded my submission. Malad, just a 2 minutes recap. Malad, here, Malad.
That's the maintainability.
Yes, the maintainability issue.
Yes.
Now, Malad, I took the point of maintainability because the impugned order is, Malad, an order passed for damages under Section 7. Now, Malad, in answer to my point of maintainability, they took 2 points, Malad. One is the order is patently illegal, and second, and there is a violation of natural justice. Now, Malad, on last day, I showed to your lordship, Malad, all the orders passed by the estate officer, whereby notice was given, show cause, reply, everything. And, Malad, the hearing was also concluded. On the date the hearing was concluded, they filed an application for, Malad, to file an application. So, Malad, that was not accepted, and, Malad, the impugned order was passed. So, I say, Malad, the natural justice, Malad,
was complied with
Section 7. And, Malad, in respect of patent illegality, Malad, I showed, Malad, I said, Malad, there can be 2 views possible. He has taken a view, maybe erroneous, Malad, following
227 interference is not part.
Malad, the last point he argued is, Malad, there is a judgment. So I said, Malad, I have not relied on the judgment. The judge on his own included the judgment in the order, and I submitted the judgment of division bench.
The judge can on his own.
Can on his own, Malad. That's my short recap.
Yes,
Yes. Malad, first of all, Malad, the dates.
So Bhattacharya will come. No,
he will come. Malad, let me just ask me to start, Malad, not to. Malad, first of all, Malad, the dates are very relevant. Malad, the notice under Section 7. Kindly, Malad, that I'm carrying a supplement, 2-page supplementary affidavit with the dates. Just with the dates.
Now supplementary.
No, Malad, it's their document. It's their document. Malad, I'll give Malad if required. Very well.
All right.
Malad, না দাদা এই তোমার অর্ডার গুলোই লাগানো
আমি দিয়ে দিয়েছি
হ্যাঁ ওগুলোই লাগানো
The notice, we'll come to that, Milad. Let's come to that. The notice under section 7 was dated 20th May 2025. Milad, it was received by the office of the petitioner that Milad recorded Milad in our reply on 27 June 12 o'clock Milad at 12 noon. Now Milad, kindly mark the dates. Our High Court Milad went into vacation on 23rd of May. No lawyers were available.
What are you saying?
I'm coming to that.
Court went to vacation.
Coming to that. I'm coming to that.
Mr. Chakraborty says he's all along available.
Vacationের কথা বলছি।
Yes. He does not go anywhere.
এখনই জাপানে
He's always available.
On Tuesday, he will continue for some time. May I go to that court? Not Justice Ghosh will take up that matter at 4:30. I think.
This is not a court.
Marar mamlata has
Mr. Chakraborty, now it's difficult. Let me see. Yes.
I'm waiting.
Yes.
Now, Milad, 20th May, notice was served on 27. The date of hearing was fixed on 27.
Mr. Chakraborty, you can leave because I have a meeting. Other matters will not be taken up today.
My lord will
I
kindly
will
come.
fix accordingly.
Not keep it on Monday. Not only that. My only prayer.
If you don't appear, what will be done?
Custody matter. It will go down.
All right. Yes.
My lord will kindly now, in the light of that, kindly take up the supplementary affidavit.
Yes.
Kindly comes to page 6.
Yes.
Milad, this is Milad order dated 20th May 2025 was served. Matter is taken up on being mentioned by SMPK representatives submit that they have filed an application praying for recovery of those. No application we have received first. On perusal of the said application, it is seen that SMPK has paid for recovery of dues and damages submitted at the principal amount of rupees 40 crores and odd for the period of 85 to 2025 as compensation charges for plate number such and such is due and payable. Representative of SMPK further submits that record of OP had preferred one title appeal. Milad, that is Milad the other part, Milad, not the association, which pending before learned Alipur Court without any order of stay. Had the submission and considered the matter on the basis of materials on record. It is seen from the records that eviction proceeding was initiated on the basis of SMPK's application dated 22nd June 2000 and after prolonged hearing this forum the final order of eviction 7th of August 2002. However, it is further seen from the record that SMPK prayer for recovery of outstanding dues were never adjudicated by this forum. On examination of the representative of SMPK submitted that the charges as claimed by them on account of the mean profit compensation damages against OP are equated to the monthly rental charges of the public premises in question, and the amount has been claimed on the basis of the relevant schedule of rent charges of SMPK as notified from time to time in the Kolkata Gazette, and that the rate of rent applicable for the damage in the rate applicable to all occupiers for the property in question. Hence, after careful consideration of the submission made by SMPK, materials produced before me, I am satisfied that the SMPK has made out a strong prima facie case to proceed against OP under relevant PP Act. I consider that the principal amount of 40 crores from the such and such as against the plate number such as payable for occupation. Milad, the matter is fixed on 27th May. Milad, it's being done ex parte. 27. Now Milad kindly comes to Milad my petition. Page 67. This order is being served with a notice of 20th May, received by us on 27th May. Kindly comes to page 67. Milad has seen this reply several times. Only for one paragraph I am showing to your lordship. Kindly see Milad second paragraph.
Yes.
At the outset, the preliminary objection which is being taken to such notice is that the said purported notice, though has been dated May 20, 2025, but has not been issued on the written date and has been received by the office of the undersigned on May 27, 2020 at around 12 noon. Fixed at 12 noon, visit by my office at 12 noon on 27th. And that is on record. Milad, I failed, Milad, may I put a question to myself, if this is natural justice? Now, Milad, kindly comes the page, Milad, kindly comes to Milad, the supplementary affidavit. Page 8. Sri Prasad has attended, Sri Prasad, at the top, Malu will find, he's a peon. He's a peon because why? Malu will get it.
Who's peon?
Martin Man's peon.
Why have you sent your peon?
Why? Because you kindly see page 11 of the supplementary.
Yes.
Mr. Devashish Kaur, who was looking after the matter, the principal officer, he was on the, because the elderly brother has suffered a massive cardiac arrest on that day. So,
the court to believe that the Martin man accepting the peon do not have any other person.
Now, yes. Because why? Because why? Because now, Martin man now, heaven difference. Martin has built this, so that building also.
It's only the peon, no other person is there. To attend the office of the estate officer.
I read the entire order. What material has happened on that day? Only the exchange of pleadings. Kindly see page 10. Kindly see page 8. Only the exchange of pleadings. That has been done. Kindly see.
Yes.
Matter is taken up for hearing. Sri B. Banerjee, learned advocate, appears before the forum on behalf of Satya Doctor Social Welfare Association, file Vakalat Nama. Learned advocate submits the subject is presently under occupation of his client and files an application praying for certain documents to file reply to show cause notice dated 28th May 2005. 2025, let such application be kept. Peruse the application and consider the matter. Department is directed to serve copy of all documents as specified by D. Banerjee. Upon receipt of all the documents, the said learned advocate appearing on behalf of Satya Doctor Social Welfare is directed to file reply to show cause dated 20th May 2020 within next day. The learned advocate appearing on behalf of Satya Doctor Social Welfare is further directed to file a copy of the photo ID, such as I am not going into that. Now, kindly, that during the course of the hearing, once Sri Prasad also appears before this forum expressing himself as a peon working in Martin Man Limited and files an application. Let such application be kept with the record. This is not application, this is that letter, page 11. On perusal of said application, it is seen that OP has prayed for time to file the reply show cause dated 20th.
That time was given.
Time was given. I filed within time.
Yes.
Only exchange of pleadings. So I am not bothering your lordship with this. So what happened? You file opposition. Opposition filed page 67. And in page 67, I am taking the point that the date has been fixed on 27, I received on 27. So without sending the peon, there is visualizes the situation. No other situation could have arisen. It's a 27, order passed on 28. Next day. Received by us on 28. Yes. So kindly turns the page. If 10 June order, matter is taken up for hearing, the representative of OP files a reply. So I file my affidavit in reply. Show cause notice, let the same be kept with the record. The learned advocate appearing on behalf of Satya Doctor also files the reply to the show cause. Let such reply be kept with the record. A copy of both the reply of OP and Satya Doctor has been handed over to the representative of SMPK. SMPK is directed to file their comments with regard to both reply to show cause notice within next day. Department is directed to serve a notice of the reply to the show cause notice filed on behalf of the OP upon the learned advocate appearing for Satya Doctor and vice versa. Parties are directed to collect certain. Let the matter come up for consideration, etc. on 10 June. It's a 10 June order. He is writing 10 June very well. All concerned are directed to act accordingly. Now, let's kindly see the next page.
Yes, how much time you will take?
I'll take some time. In reply, how much time? Because I have to show this order.
Not in facts.
Not in facts.
The points you have to.
This was
again
because this was given back. No, this was handed over when him reply by him. What? Last day in reply, these orders were handed over by him.
But the orders are self-executed.
We're aware of this. We're aware of these
I'm not
orders.
saying, I am only saying, my endeavor is that,
It's difficult.
my endeavor is that,
Yes.
there has been no hearing 7 except 17 June.
That you have submitted. That
It's
you have
only
submitted.
exchange of pleadings that are offered. I have no complaint with that.
All right. I will consider that if you want to make any submissions on the decisions which you have cited.
Yes.
Yes. How much time it will take?
Any day 15-20 minutes.
20 minutes.
Decision he has cited and I'm also led by Mr. Bhattacharya. And leave something for him. Any day 15 minutes.
Bhattacharya is very busy.
He has attended every day, I hope
He has attended. Now it will be difficult because the puja vacation is nearing. You will be very busy. You will be very busy.
রিটেন নোটস ফাইল করে দিও
সব কি তুমি লিখে দাও তাহলে এক কাজ করো any day 10-15 minutes any day আরে অর্ডারটা দিতে kind one line last day last day kindly don't leave anything
We'll take
There will be difficulty on, but accepting binding precedent that
Lordship, kindly allow me.
study matter.
what has happened? It is appearing in the list.
Not on Monday. Kind of marked it.
It is appearing on which for which date?
No, it is appearing marked for 3 release.
Yes.
Now, Lord, University is taking up the monthly matter first. If it is taken up on Monday, I have some difficulty.
Mr. Chakraborty is not fixed. I am changing. So it's not that monthly list will be taken up fast.
So not on Monday. I'm saying I have some difficulty. Monday.
Right.
Then if adjournment is taken from there is the later.
Remember this that you will not embarrass the court.
I know. Some difficulty.
Ask your junior to mention. Ask your junior to mention. I'm telling you.
Out of list করে দিলে বিপদ হয়।
Yes. Someone has to be present. Otherwise,
Item number 19, I was stuck in court to number 28.
item number
19, my lord, kindly make it not to be your lordship.
What has been done?
I was in court to number 28, I couldn't appear, my lordship.
What has been done?
Dismissed for default. Kindly make it not.
When it was dismissed for default?
At morning today, my lordship. Today, my lordship.
It has not been dismissed for default, madam. You have not checked and you are mentioning.
They have.
But
They
it
are
is.
saying it has been disposed of, not.
We can make it not to the lordship. I was asking, I'm for the petitioner, my lordship.
Yes, it has not been dismissed for default, they are saying.
কি হয়েছে এটা? Disposed of.
কি অর্ডারটা হয়েছে দেখো একটু ইউটিউব করে দেখে